public hearing. Attorneys, attorneys, can you throw your P number in the chat box? I mean, we have it, of course, we'll hear it when we hear your appearance, but it makes it easier for the court reporter. And if we miss it, we can always reference it on Zoom. Where it is, but yeah. All right. Thank you, Mr. Yaldo. Well, Mr. Green. And then UCAC, I think you all have an idea, a good idea of how we use the lobby, but let's make sure we're not meeting anybody in the UCAC lobby, just so that if I invite somebody over, they don't hear anything they're not supposed to hear. I think you all have already been doing that, but FYI. All right, Mr. Horka.
Got a couple dismissals we can knock out, Judge, if you're ready.
All right, let's knock out some dismissals and then we'll start calling some names. And if parties need to speak, yell some names, free, don't be shy. Which ones are dismissals, Mr. Horka?
Cox case at 8:30 ending in 468.
Calling case number 2334-6468, City Living LLC versus Jessica Jennings.
Morning, Joe Horka, P75969, appearing for the plaintiff and moving to dismiss.
This matter is dismissed without prejudice.
Hello. Hello, I'm sorry.
6-8. Yes, sir. Good morning.
Good morning. I'm sorry to interrupt and stuff, and I apologize. But my name is Anthony Cummings, and I got a brother that's on life support, and I have to be there to sign off. And I mean, in front of everybody. But my brother.
Judge, this is my case. Judge, this is my case. Mr. Horka and I are on it. I think if I could talk to Mr. Horka briefly, I think we should be.
Yeah. If not, I'll set it over. Just take care of your business and we'll figure it out.
Mr. Cummings, I'll call you later. Deal with your brother.
Okay, thank you very much. I appreciate it.
You're welcome.
The other dismissal now, Judge, or I'm happy to talk to Mr. Phillips and handle it later.
I mean, we can just set a new court day to make sure he gets a notice. Did he log off already?
I think he did, Your Honor. I can let him know, though.
Okay, no, yeah. So don't worry about that, Mr. Horka, right now. Just mark it, and later on in the docket, you all agree to another date. We'll just let him know or notice it out. I'll make sure I don't keep on or anything.
Okay. And the other case I had was ending in 550 at 9:30. It's a Landau case.
Calling case number 2239-5550, Plymouth Nonprofit Housing versus Ajane Johnson Jr. and all occupants. Wow.
Good morning, Joe Horka, P75969. I'm standing in for Mark Landau for the plaintiff and moving to dismiss.
This matter is dismissed without prejudice.
Thank you.
Your Honor, can I get breakout privileges, please?
Absolutely.
Can I also, Judge? Good morning.
Good morning, Mr. Santiago. I got my bike tire fixed, Mr. Santiago.
I'm happy to hear that. Always encouraged when people ride, Judge. Good for you.
All right, let's see. So let's get through this 8:30 docket. Frederick Robinson here? And Mr. Santiago, Mr. Newman, you have Miriam Irby and Natasha Gatson at 9:01. Those look like they're both adjourned matters. Are these the only 2 matters you have?
Yes, that's correct, Your Honor.
Okay. Mr. Santiago, is Ms. Gaston here?
She is, Judge. I'm about to ask her to go into a breakout room with me, and then I will talk with Mr. Newman.
Okay. All right, you
Thank
all just
you.
let me know when you're all are ready.
Will do. Thanks, Judge.
All right.
Thank you, Your Honor.
Welcome. And Attorney Zaid, see you only have one.
Good morning, Your Honor.
Morning. Is Lockie Williams Hezekiah here?
That's my case. I don't believe they're present.
Okay, default's to be called at 9:30. I just see Attorney Green, you have one case. And I know someone else is standing in for Attorney Green. He is, no, Jonathan Green. Or,
I'm here, Your Honor, on the Yaldo case.
okay, all right. Yaldo's the plaintiff, not another attorney. Okay.
Correct.
Is Tom or Tina Stafford here?
Yes, Tina Stafford.
All right. Would you like to speak to Mr. Green?
I don't think so.
All right. Do you have an attorney, Ms. Stafford?
No, I don't.
All right. Are you seeking counsel?
Am I speaking for myself?
Yes. Are you speaking for yourself?
Yes.
Or do you?
Yes, sir.
All right. I'm going to put you in a breakout room with Mr. Green. He's the attorney for the landlord. If you all work something out, just let me know, or Attorney Green will let me know. Attorney Green, if she asks for counsel or she doesn't understand what the terms of the deal are, refer over to the breakout room of Michigan Legal Services, or send someone from Michigan Legal Services to chat, and we'll figure it out. But both parties are here. I see no reason why you all shouldn't have a conversation. So most likely you'll work something out, and then just let me know. I'll invite you to room 6.
Thank you, Judge.
Welcome. Attorney Lawback.
Good morning, Your Honor. I'm actually standing in for Attorney Lauback.
All right. Good morning, Attorney Freeman.
Yes, that's correct, Your Honor.
All right. Is Ricky Splight here? Ricky Splight. See if Ricky Splight. Looks like Chantel is in the waiting room, but doesn't sound like Ricky Splight. So 9:30 in the event defendants don't appear. If they do, just let us know when you're ready. But I have you checked in. Attorney Smith, I see you have one.
Yes, one, Judge. Actually, I have 2, Your Honor.
Okay. What's the address on 459?
It is
The Zoom meeting for the landlord.
10442 Lake Point, Your Honor. That's an occupant's case 10442 Lake Point.
10442 Lake Point.
Correct.
Does that sound familiar to anyone? Is that where you reside or occupy? All right, keep an eye out. And then which Destiny Smith or Prescott Smith, are you here? Hit star 6 if you're on the phone. Unmute if you're not. It looks like you're over 2. Attorney
I'm
Smith.
over 2. I'll wait, Judge.
Right. Attorney, all right, let's see. Let's call a few more. Let's call the rest of yours, Mr. Mood, and then I'll get to a few more of these onesie twosies. So is Frederick Robinson here? Is Tequila Jones here? Miss Jones, I see Miss Jones. Good morning, Miss Jones.
Good morning.
Do you have an attorney?
No,
Do you want to speak directly with plaintiff's counsel?
I don't know.
Okay, do you want to speak to the landlord's attorney and try to work out a deal? Or do you want an attorney to try to work out the deal for you?
I can speak to the landlord's attorney.
Okay. All right, Ms. Hamoud is here. I'll invite you into a breakout room. So watch your screen. It's going to have an invite. It's going to be an invite that pops up. Do you see it?
Room 11?
Room 11. And I'll invite the attorney to room 11 as well.
Thank you, Your Honor. I just have a quick resolution to put on the record for, with Ms. Adriana Palmer. It's for matter ending in 6380.
Okay, so Ms. Jones, once we put this other case on the record, she'll be in that breakout room. Said Ms. Palmer, okay, calling case number 2334-6380. This is Rita Piles versus Adriana.
Good morning, Your Honor. Nasreen Hamoud, P number 80522, appearing on behalf of the plaintiff.
Thank you, good morning, and is Adriana Palmer here?
Yes,
Ms. Palmer?
yes.
All right, can you state your name for the record?
Adriana Palmer.
Thank you. Good morning.
Good morning.
Ms. Hamoud,
Yes, Your
where we
Honor.
been work out?
We worked out a resolution to allow Ms. Palmer to remain at the property until June 20th, 2023. That'll be via a judgment against all occupants with Ms. Palmer's name removed as a named defendant.
Okay, so this will be a judgment by hearing where Ms. Palmer, you'll be removed as a named defendant in this case, but a judgment will be entered against all occupants. And all occupants must vacate by June 20th, 2023, or a writ of eviction can issue after that date. Do you
Okay.
understand?
Yes,
So June 20th, if parties vacate, no writ of eviction will enter, but name is removed as a named party and all occupants will be on the judgment. So if you need some, it may assist you a bit, but you still have to vacate by June 20th.
okay.
All right, you have a great day and keep an eye out for a judgment. The judgment should be in the system and it may come in the mail within a week or two.
Okay, thank you.
You're welcome.
Judge, I apologize for interrupting. I was disconnected briefly. Can I get
Yes.
host powers again? Thank you.
Sorry. Excellent. Okay, iPhone in the corner. What's your name? Yeah,
Lakaya.
Lakaya. What time is your case? Okay.
It was at 8:30, but I put the wrong I put the call number in and not the my son had to tell me that was the wrong one.
Okay. Happy Mother's Day.
Thank you so much.
All right. What's your case number?
Hold on 1 second. Let me grab the paper. Case number 233-46392.
46392. You're with Mr. Zaid 06.
Okay.
How you say your last name? Williams Ezekiel?
Yeah, Hezekiah.
Hezekiah, okay, thank you.
You're welcome.
So, do you have an attorney? These are your options. You either can speak directly to the attorney for the landlord, or you can speak to an attorney from legal aid who'll do an intake, tell you if they can represent you, and then represent you with the landlord.
I could just go ahead and talk straight to the landlord of the plaintiff, I believe.
All right, so we'll put you in quick. Let's see, this is 392 for ESPN. LWH. Just putting in a quick name. Mr. Zaid. I'm going to invite you into a breakout room with the attorney for the land. And then when you all come out, just raise your hand digitally. It's a box.
Okay.
And I'll call your case.
Okay.
All right. So do you see that invite? Nope. Hold on.
Okay.
Did you see an invite?
No, not yet.
Do you
Okay,
see it
I
now?
got it. I got it.
All right. Okay.
Good morning, Your Honor. This is Alan Dyer.
Mr. Dyer, happy Monday.
Happy Monday to you, Your Honor. I have one case with you set at 901 ending in 790.
Was it a dismissal?
It was not, Judge. It was adjourned from Monday, May 8th.
Okay, Alexis Lewis. Is Alexis Lewis here? Is that the one you're referring to?
Yes.
Yes.
Okay.
Yes, Your Honor, I'm here. My camera won't turn on though. It's saying make sure that your camera is powered, and I'm on my laptop. So I know it's on.
I have that issue sometimes. You all can still, it's all right. Ms. Lewis.
Okay. But yes, I'm here.
All right. Would you like to speak with Attorney Dyer? Do you have your own attorney? What's going on?
Yes, I would like to speak with Attorney Dyer.
Let's get you all in the breakout room.
Thank you, Your Honor.
So much.
I'm gonna miss these breakout rooms a little bit. Go back in person. Room 15.
Okay, thank you.
Hello, Your Honor.
Yes. Come on.
This is Kimberly McKinney, and my case number is 035. And my attorney is Mr. Ted. Huh?
Your attorney is Mr. Ted Phillips. Yes, ma'am.
Okay, I just wanted you to know that I'm here.
Okay.
And I've been here.
Okay. Thank you.
Pardon me?
Hello?
Okay.
I have you checked in. Thank you.
Hello?
Thank you.
You're welcome.
Trying to get
Mr.
checked in,
Sabree.
Judge.
All right, what's your name? Who's trying to get checked in with the hand up?
Sherelle Rowland, OBA Property Management.
Are you a defendant?
No, I'm not. I'm the plaintiff.
Okay, and are you represented by counsel?
Yes, I am.
All right, so who's your attorney?
Sir, I don't know because I get a different one all the time.
Are you the landlord or the?
Yes, I am.
All right, well, what time is your case scheduled?
9 o'clock. It was on the 8th. We went in at 1:30, then they adjourned it to 9 o'clock this morning.
Number 2 properties?
Pardon me?
What's the name of your company?
OBA Property Management.
I have you checked in. You were with Mr. Fleshman this morning.
Fleshman?
Yep, Attorney Fleshman. That's your attorney.
Okay.
There's an attorney on the other side. Is Stephanie King here?
Yes.
All right, Stephanie King's here, Judge is here. Mr. Flesland will talk to them, and once he talks to them, he'll update you.
Thank you.
I already talked to Mr. Kirby this morning before court.
All right, I'm gonna leave it to you all, Mr. Flesland and Mr. Phillips, just let me know your cases.
I haven't seen Mr. Phillips yet. Is
Around here somewhere.
okay.
You might want to check the breakout rooms. Keep an eye on the breakout rooms. It looks like he's talking to Mr. Horka.
Mr. Sabree,
Yes, sir.
I'm trying to get checked in. I've been on here since 8:25.
Yeah, everybody has, and
Yeah.
you know, that's the whole
I'm
thing.
at work.
All right, so Christopher Franklin,
Yes,
you
sir.
are
That's
with
me.
Ms. Hamoud. Ms. Hamoud, are you here? Ms. Hamoud is, I think she's in a breakout.
I saw his name on there, or her name, whoever she is.
And she's talking to Tequila Jones in room 11. So
Okay.
you're one of her 4 cases that are left in the Tequila
Okay.
Jones, she's done with her. It'll be one of 3 left. So you need to talk to her.
Okay, thank you.
Work something out. Keep your hand up. If you want legal counsel, they're here. But it may slow you down time-wise, but that's not, you know, if it's important, it's important. I'll leave it to you. But Ms. Hamoud is in room 11. When she pops out, we'll probably put her case on the record like we did her last one. Then you go in and talk to her, and then we'll put it back on the record.
Okay, thank you.
You're welcome.
Judge, this is Alan Dyer again. We are ready to roll on 790 whenever you are.
Okay, and then Mr. McClurkin.
Yes, Your Honor.
I'll address you right after I call this other case. Whatever's ready, I'm calling it. That's how we keep the docket moving. So,
Excuse me, John Green here for the Yaldo case. We also have an agreement to put on the record.
okay, so I'll go Dyer, then McClurkin, then you. All right, and then, so Attorney Dyer, we are on calling case number 233-44790. This is Lexus Lewis, Dwayne Williams versus Lexus Lewis.
Good morning, Your Honor. Alan Dyer appearing on behalf of the plaintiff P54857. I do understand that my client Dwayne Williams is here as well. Mr. Williams, you want to state your name for the record?
Look,
I'm not sure if he's muted, Judge, but we can just simply proceed.
Okay. And Ms.
Dwayne Williams.
Oh, there he is.
Williams. And Ms. Lewis, can you state your name?
Lexus Lewis.
Thank you.
You're
All right,
welcome.
party.
Okay, Judge, we did have an opportunity to discuss the matter briefly in a breakout room. I understand that this matter was up before the court back on May 8th, and my law partner, Randy Levasseur, and my law partner, Randy Levasseur, covered the hearing. It was adjourned to this week. I do understand that there was a prior termination case that was handled approximately a year ago. It was dismissed by Judge Sherman in August. I'm told it was dismissed based upon an allegation of retaliation.
Retaliation. Yes.
Ma'am, I won't interrupt you.
I'm sorry.
Ultimately, Judge, I'm told it was dismissed as a matter of retaliation. However, that dismissal took place back in August. There were no further orders entered by Judge Sherman other than the dismissal. I understand that Ms. Lewis is alleging that indeed there was a repair order entered back then. We can't find it on the ROA or anywhere else. We believe there's simply an order of dismissal. Moreover, we are now almost a year later, Judge, and we are simply looking for possession of the property. We gave a proper notice to quit. No rent has been paid in all of this time, and we believe that we're entitled to take possession of the property. My client's looking to move in a different direction, and there's no lease term that's unexpired.
Okay. And Ms. Lewis?
Yes, Judge. He is correct about there being a case about retaliation. And yes, we did go through with the case and the judge dismissed it because Mr. Williams was trying to basically put me out a month after I moved in and complained about things being broken in the home. My home was vandalized while I was in the hospital giving birth to my child. Mr. Williams claimed he had no knowledge of it until another landlord called him. He never called me. Now, fast forwarded, I haven't heard anything from Mr. Williams. I was waiting for him to come by, fix what he was supposed to fix so that he can receive his money, Your Honor. He never came by. I got a notice in the mail saying a notice to quit. Now we're on a month-to-month lease. So my lease is still valid, by the way, and I have a copy of it. Mr. Williams told me, well, Miss Lewis, if you tell me you can move out by this date, I'll give you your money that you paid me to move into this place because I know what I did was wrong. I say, okay, Mr. Williams, that's fine with me. A mutual, verbal agreement. Your Honor, I keep getting these notices in the mail, basically like he's trying to get me some type of something on my, I don't know, I can't call it. But if you're telling me that you're gonna return my money to me and to move out the premises, that's what we should be doing, not me coming to court because I keep receiving notices like it's something else going on.
Judge, the only issue before the court today is our claim for possession of the property. No other claims for monetary relief from either party against the other is involved today, and nor are they prejudiced.
I'm sorry, because that was verbal, and like you guys told me, sir, you told me that had nothing to do with you guys, and that if Mr. Williams agreed to that outside of court, that was what he agreed with. So that has nothing to do with you, sir. That's on Mr. Williams' behalf, and that's the reason of us all being here, because Mr. Williams are telling you guys, I want possession of the property, but he's telling me he'll give me my money back because he know he scammed me into moving into this place.
Ma'am, I understand you interrupted me again, and I'm trying not to interrupt you. I was talking
to the judge. It was my turn to talk, though, but I'm sorry if I'm wrong, because you're an attorney and I'm not.
That doesn't change anything.
I was in the wrong for not speaking. You spoke when I was speaking. Excuse me, Your Honor. Excuse me.
If you're not done, ma'am, you continue.
I'm done.
Okay, Judge, the only point I was making when I thought she was done previously was that indeed this is a possession case. Ultimately, if no other claims are prejudiced, if she claims to have some other verbal relationship or understanding with my client, I would argue that that's not enforceable under the statute of frauds. But ultimately, again, it isn't part of this claim for possession. My client hasn't received rent in almost a year. He has every right to take possession of the property. She admits it was a month-to-month tenancy, which the court can take judicial notice, can be terminated by a simple 30-day notice to quit, which was sent long ago. We have provided the court with a copy of the deed as well as the lease agreement evidencing the month-to-month relationship, Judge. We are asking for entry of a judgment.
Sir, I'm sorry, but for me to pay rent, my unit has to be up to par. Mr. Williams has not been out here to fix anything. That was the whole point of the matter in the first place of the case being dismissed. It was retaliation of me asking for him to give me my money back or let me move out of this place that was not up to par for me and my kids. I had to make it that way. Mr. Williams knows his wrong in all of this, and he knows that he was supposed to do what he was supposed to do when the judge entered the judgment. He never came by to do any of that. Now he wants to take possession and leave me screwed and without giving me my money back like he verbally discussed with me, but keep entering notices on me. I haven't paid rent because he hasn't come by here to fix anything. Are you listening to me? I will pay my rent if he will come by and keep my property up to par. My house has been vandalized. Mr. Williams has not came by to fix that yet.
Ms. Lewis.
Yes.
I hear everything you're telling the court.
Yes.
And I appreciate you voicing your issues because you may have a verbal agreement with your landlord.
Yes.
That may still be valid, but we don't have any evidence of this verbal agreement. So
can you talk to Mr. Williams?
No. Is there any objection to an all occupants judgment?
There's not, Judge.
All right. I know you all may not be best of friends, but the attorney Dyer is offering an all occupant. He's saying that he'll put the judgment in all occupants. And I don't know if you all can decide on a vacate date, but that's one scenario. Based on paperwork, there's a deed, there's a notice to quit, a summons and complaint for termination of tenancy. This is a complaint to recover possession of property and is not related to any rental amount.
Correct.
And
He
notice,
wants to, I'm sorry.
so any rental arguments aren't really true relevant. They aren't relevant as it relates to this case. This is not related to a prior case, and I know a prior action was filed and it may have been dismissed, but this was going about properly. So if you still have some type of agreement with your landlord, get it in writing or do your best to try to enforce it. But today is the day and time for a termination of tenancy for you to vacate the property, not for you to redeem it. So it's a matter of when versus, because there is no offer to redeem unless you work it out with your landlord. This is a termination of tenancy case. You understand what I'm saying?
I understand what you're saying. So basically you're saying that me and Mr. Williams need to come to an agreement on when he can return me my payment and then I'll be moving out. Basically, like behind the curtains, like.
And today is the day and time to determine when you'll be moving out. I don't know when, how, and where that negotiation for the payment will occur. But that's also not in front of this court today. So I can't adjourn this matter for you to negotiate something that's not at issue this morning. However, Attorney Dyer is willing to enter this judgment today as an all occupants judgment. I may be able to give you a little bit more relief than he's giving you, absent his objection, or overruling his objection. But today is the determination of when you can vacate.
Well, Your Honor, I need time to know when Mr. Williams plans on giving me my payment so that I can move out of this unit.
I just said that this is not determinant on your payments. That's an oral argument that has nothing to do. Well, it has something to do with your housing, but you have no proof, and it's not an issue today. There's nothing in here that says that. Nothing I'm reading says that you can redeem your property. There's a termination of tenancy with the deed in the file. So we have to make a determination today on when you plan to vacate. Mr. Dyer seems as if he's seeking a statutory amount, which would be May 25th. I'm willing to put it out toward the end of the month, and it's an all occupants judgment. So what would you like to do, ma'am?
I need like some type of counsel, like some type of something, because this is not right at all. This is not right. I'm not understanding.
Okay.
I'm not understanding how all of this is even.
Are you asking for an attorney? You want me to explain it to you?
Yes, I really need like an attorney because I'm not understanding how this is.
No. Talk to your attorney about what you don't understand.
Okay.
I had a big this morning, and I'm pretty sure I asked you, did you want an attorney initially before going into this? But I'm going to invite you.
No, I'm only saying that, Your Honor. I'm sorry for the confusion.
No. If you want an attorney, I have no problem. Please speak to them. But this is the date and time, and we've laid out what we're here for. So when you speak to an attorney, let me know when you're ready. And Attorney Dyer, she wants an attorney, and attorneys are available, so I invited her to UCHC lobby. Please let me know. You're welcome. Attorney Green, and then we'll go down. I assume a few people are ready. So Attorney.
Your Honor.
Go ahead.
This is
Yes, ma'am.
Attorney Fisher. I don't have breakout privileges and I need to talk to Attorney Anthony McClurkin, and I haven't been able to chat him to let him know that.
All right. Sorry
So we
about
need
that.
to go in the breakout room.
All right.
Thank you.
Thank you all. You couldn't even get out of your breakout room. Could you?
No. Attorney McClurkin, can you join me in breakout room 17?
Sure, I will.
Thank you. Thank you. Thank you, Your Honor.
Oh. Yeah, that's a problem. All right, Attorney Green, and then Attorney Zaid, we'll just go down the line.
Thank you, Judge.
Let's see, are you ready on your matter, counsel? Attorney Green, are you ready for this case to be called?
Yes, we are, Your Honor.
Okay, calling case number 23346-402, Mike Yaldo versus Tom and Tina Stafford.
Good morning, Your Honor. Jonathan Green on behalf of the plaintiff. Mr. Yaldo is here with me in my office behind me. I don't see Ms. Stafford on the screen anymore, but she and I reached an agreement, a judgment for possession against her and any and all occupants. She has until June 4 to vacate. If she doesn't, a writ of eviction should issue, or shall issue, excuse me.
June 4th?
Correct.
All right, let's see. And what's the total, what's the amount to retain, counsel?
$2,000.
Okay. $2,000 must be paid on or before June 4th or writ can issue. All right. Is Tom or Tina?
Excuse me, Your Honor. She's actually agreeing to get out of the house. It wasn't anything where she's writ of possession.
All right, so this case has been, was she in agreement of converting this to a termination?
Correct. Correct.
And will you be submitting?
I'm sorry, you got cut off by the beeping. You said, will I be submitting?
Will you be submitting a, have you gotten her consent?
Yes, I have, Your Honor.
Okay, all right. So parties will convert this to a termination of tenancy case, whereas Tom and Tina Stanford and all occupants must vacate by June 4th, 2023, or a writ may issue.
Thank you, Your Honor.
I will note that parties were here earlier. However, they worked in agreement and dropped off of the chat, but you have their consent. So feel free to enter it as a consent and the court will sign it.
Thank you, Judge.
You're welcome. Have a great day.
But this is some other cases I want to check in. No, my case don't start at 10. So before I had to check in.
All right. Let's see, Mr. Santiago, Mrs. Zaid.
We're ready, Your Honor.
All right, then Mr. Santiago, you're next, unless you have something quick you need to.
Nope, Judge, I will wait. Thank you.
Calling case number 23346-392. This is JMZ Management versus, I think it's Lakia. I'm sorry, it's knocked off of the initial form, but Ms. Williams, Hezekiah.
Good morning, Your Honor. Justin Zaid, P81051, on behalf of the plaintiff, JMZ Management.
Ms. Williams, Hezekiah, you can go back on mute, but I need you to state your name.
My name is Lakia Patton.
Okay, and do you reside at 199414?
Yes.
Okay.
Your Honor, this is the date and time set for a formal hearing. I did have an opportunity to speak with the defendant. At this time, we have reached a consent judgment whereby the rent to retain is $14,360. And we are asking that if she does not pay or move out within 14 days, the plaintiff may apply for a writ of eviction.
And what's 14 days?
That would be the 29th, Your Honor.
Okay. So, Ms. Patton, do you agree to pay $14,360 or vacate by May 29th, 2023?
Yes, sir.
All right. So in the event that amount isn't paid, or if you don't vacate, a writ of eviction can be filed after May 29th.
Okay.
Also, no, go
I
ahead.
apologize. I'm actually, if you can see, I'm actually in the middle of moving out now. So this was like perfect timing for me.
You were breaking the court's policy, so I cut your camera off.
Okay, I'm sorry.
But it's okay. Well, MCR 4.201I, it applies to you because you're unrepresented. You can file a motion in 3 days, and if it has some merit to it, you can set this aside. But you have a judgment, $14,360 to be paid, or for you to vacate on or before May 29th. It sounds like you'll be well ahead of that. So good luck, Ms. Patton, and look out for your paperwork.
Okay, I have one more thing, Your Honor.
Okay.
The judgment that you guys have, that is in my teenager's name. It says Lakaya Williams and Hezekiah Williams. Those are my children. I don't know how they named Cat head of the lease, but it's supposed to be in my name, not my kid's name.
All right. Is there any objection to an all occupants judgment in this?
No, Your Honor, that's fine.
All right. This is going to be done by hearing judgment. So it's a judgment by hearing where all occupants must vacate by May 29th, 2023, and all occupants can redeem at an amount of $14,360.
Yes,
so
sir.
MCR 201 wouldn't apply, but this is an all occupants judgment. It may have it definitely serve your kids better in the future years, and you still get that result. But it won't preclude you, counsel, from any action in civil court in the event that that was planned. So
Understood, Your Honor.
And you are free to go, Ms. Patton. You have a great day. Mr. Zaid.
Thank you.
Your Honor, do we need to prepare an order?
Prepare an order, yeah. If you can prepare an order and submit it to the court, we'll sign it.
Okay, thank you, Your Honor.
Mr. Santiago, and then we'll just keep going down the line.
Perfect, Judge. This one is with Mr. Newman. It is case ending in 287.
And Ms. Hamud, did you talk to Mr. Franklin?
Yes, Your Honor, we do have a resolution to put on the record.
All right, I'm calling him next because he's got a job and you can't pay rent without a job, so.
Thank you, Your Honor.
Thank you, sir.
You got it. And Santiago, you said 287?
Correct, Judge.
Calling case number 2345287, Maxwell Homes LDHA LP versus Natasha Jackson.
Good morning, Your Honor. Philip Newman appearing on behalf of the plaintiff.
Good
Thank
morning,
you.
Your Honor. Robert Santiago, Michigan Legal Services, P57157, on behalf of the tenant Natasha Gaston, who is present in the courtroom, I believe. Ms. Gaston, could you please state your name for the record? Well, Judge, I don't know if she fell off or not. Hang on, let me
I
check
have
the
both.
breakout. You know what, Judge, let me bring her out of the breakout room.
Okay. So, telephone.
I'm not sure, but I don't know if she was able to get out or not. Ms. Gaston, could you please state your name for the record?
Natasha Gaston.
Thank you, Ms. Gaskin. Good morning.
Good morning.
All right, Council.
Your Honor,
Would
this
you like
case-
me to go, Phil, or Philip?
Yeah, go ahead, Robert.
Judge, we are doing a conditional dismissal under 4B with a pay or vacate date of June 15th, 2023. Mr. Newman, could you recite the exact amounts in terms of the past due balances of today plus the court cost?
The amount of rent to retain possession is $4,690. Costs are $159 for a total of $4,849. That does not include the June rent.
All right. Is that your understanding, Ms. Gaskin?
Yes.
All right, it's not June yet. It's the middle of May. June rent is what, $900, $898? Is that what it is? Ms. Gaskin,
Yes.
what's your rent? What's your monthly rent?
$896.
Okay, $896. So $900 basically. And this is, so that $900 still has to be paid. That June rent still has to be paid. I know it's not exactly $900, but might as well call it $900. But right now you're entering into a conditional dismissal, but on a condition that you either pay $48.49, which is what's owed now, or vacate by June 15th. This case will be dismissed. If you don't pay or vacate, either or, by June 15th, a judgment and a writ of eviction can be filed at the same time without going back to court. Are you aware of that?
Yes.
Okay. And does Mr. Santiago have permission to sign your name on the conditional dismissal?
Yes.
All right, the court is satisfied, and have a great day. Good luck with fulfilling the terms of your agreement.
Thank you.
Thank you, Your Honor.
Thanks, Judge. Thanks, Philip. Take care, Ms. Gaston. And Philip, I will email you this afternoon or tomorrow morning the proposed CD.
Great, thank you.
All right, Attorney Mahmood, calling case number 23346379. This is Enville Rod LLC versus Christopher Frank.
Nasreen Hammoud, P number 80522, appearing on behalf of the plaintiff.
Thank you. Mr. Franklin, can you state your name for the record?
Christopher Franklin.
All right, Mr. Mood, what were you all able to work out?
Yes, Your Honors, we were able to agree on a vacate date of June 20th, 2023. That will be via a judgment against all occupants with Mr. Franklin's name being dismissed as an independent.
What? And this was initially a termination of tenancy complaint. So we'll do a judgment by hearing where Mr. Franklin's name is removed as a named party, but all occupants, which the name of the judgment will be in, all occupants must vacate by June 20th, 2023. A writ of eviction can be filed after June 20th, 2023.
Yes,
So
sir.
that concludes this matter. Good luck, Mr. Franklin.
Thank you, Judge.
Thank you, Your Honor. I also have a quick resolution to put on the record for matter ending in 6378 with Ms. Tequila Jones.
Yeah, let's get Ms. Jones out of here too. Calling case number 23346378, Furious 5 LLC versus Tequila Jones and all occupants.
Nasreen Hammoud, P number 80522, appearing on behalf of the plaintiff. Your Honor, this is also a termination of tenancy matter. I did speak with Ms. Jones. We agreed to a resolution to allow Ms. Jones until June 20th, 2023 to vacate the property. It'll be a judgment by hearing against all occupants with Ms. Jones's name being removed as a named defendant. Is that correct, Ms. Jones? Ms. Jones?
Ms. Jones. All right, let's see. All right, so this is an all judgment. This is a complaint to recover possession where all occupants must vacate by June 20th, 2023. Is that correct, Counsel?
Correct, Your Honor.
All right. And the court recognizes that Ms. Jones is here. This is the statutory 10 days. And did you have an opportunity to speak to Ms. Jones, Mr. Moot?
Yes, Your Honor.
All right. The court is satisfied with entering this judgment against all occupants. The judgment by hearing for all occupants must vacate by June 20th, excuse me, June 20th. It
Yes.
is Tuesday, right after Juneteenth. June 20th, 2023, or a writ may issue thereafter. Good luck, Ms. Tequila Jones. You are free to log off. Hopefully you were listening.
Hold on 1 second. I'm just muting court this week, Davey. Hi, I just was muting court so I could hear you. I'm in court right now, but what's up? What's going on?
Yeah, we appreciate you, Mr. Gotta mute you. All right, Attorney Woodrow.
Yes, Your Honor.
Right, you're next up in the queue. Do you have, let's see.
This case ending in 318, Your Honor.
318. What time is this scheduled, Counsel?
8:30.
Madam Court Reporter, could you give me?
So we're on? I'm sorry, Your Honor.
Attorney Woodrow, what's the case number?
23346318.
Yes, Judge, what's that? 2334. This is in Judge Sherman's courtroom, Millicent Sherman's courtroom.
Oh, fantastic.
I know, right? It was a case from, it looks like the 11th. So what was the 11th? It was Thursday, May 11th. Defendant failed to appear, plaintiff appeared, awaiting default judgment, vacate by May 23rd, 2023. Let's see. Is this Eric Place versus Eric Fountain?
No, this is John Peabody versus Kayla Grigsby, Your Honor.
All right, that's okay.
Again, 23346418. Yes.
Okay, I put in 63. I don't know why I told my clerk 6318. Okay. I have you checked in. Is Kaylin, you say you're ready on this matter, counsel?
Yes, I am, Your Honor.
Yeah. Back to square one. Calling case number 23346418.
Again, Your Honor, Hugh Woodrow, P56468, appearing on behalf of the plaintiff, John Peabody. This is date and time set for the second hearing on this matter. The defendant failed to appear at the first hearing on May 1st. this point, we're asking for a default judgment to be entered.
All right, is Kaylin Grigsby here? Kaylin Grigsby, anybody on West Hancock, apartment 11? West Hancock, apartment 11. All right, counsel, you've requested a default judgment. Do have a proof of service notice. How much rent is actually owed currently?
The amount of rent is $1,620 plus $156 in court costs for a total of $1,776 to retain.
1776 to retain. So default judgment is granted. Defendant must pay $1,776 or vacate. Are you seeking a statutory days, counsel?
I am, Your Honor.
Okay, or vacate by May 25th, 2023. Anytime after that date, a writ of eviction can issue. It's the default judgment, defendant failed to appear.
Thank you, Your Honor. Have a good day.
All right, you're welcome. It's Kaylin Grigsby, 418-6418.
Morning, Your Honor. Can I check in?
Hold on 1 second. With James C. All right, what's your case number? Let's do it.
I honestly do not have my case number handy. I'm at work. I left the paperwork at home.
Put your hand up in the chat when you find your case number. I can't check it out. Okay. All right. Mr. Marquez.
Sorry, Judge Bridge just called me at that exact same time. But I'm ready.
Go. You said you're ready? Are you back?
Yeah, it's coming. The video's coming out. Sorry. Oh.
Zoom. Attorney Smith.
Ready, Judge. Call out for a couple potential defaults.
0442 Lake Point. Is anyone at 10442 Lake Point? 459. One at a time. 10442 Lake Point. Let's see if Michael Duncan lives at this address. Calling case number 2334-6459. This is Domus, D-O-M-U-S PM versus at 10442 Lake Point Street. Anyone live at 10442 Lake Point? All right, counsel.
All right, sorry to interrupt, Judge. I do have that case number for you.
All right, hold on 1 second. We're in the middle of a hearing. Can you put it in the chat? Thank you.
Your Honor, Justin Smith for the plaintiff on this case, P51886. This is a second hearing for a termination of tenancy at the subject address that you cited. I would be proposing to submit a default judgment as of today's date with a 10-day writ of restitution date on it.
All right, and this is a complaint for possession of property. So the default judgment, no amount to redeem, termination of tenancy case where defendants must vacate by May 25th or a writ may issue. That's May 25th, 2023. Defendant failed to appear. Default judgment is granted.
Thank you, Your Honor.
4-5. All right, James C., what's your case number? James, moving too slow this morning. Mr. Dad. Oh, you have another one, Attorney Smith?
I do, yes, that 484.
All right, James, what's your
Yeah,
case
yeah,
number?
I was muted, man. 233-454-83.
483.
Oh, I got 233-454-83.
Let's see if you're in the right spot. All right.
Judge, he in the right spot for 9 o'clock.
Okay. All right. Who's let's see. Charles Chalmers. James Chalmers, you're with Attorney Horka. Do you
Yes,
want an
sir.
attorney? Or do you want to speak directly to the plaintiff's, the landlord's attorney?
I do request an attorney.
All right, I'm going to invite you in the breakout room. Someone will talk to you. All right, Attorney Smith, we are back on calling case number 2334-6484, First Rent Corp. versus Destiny and Prescott Smith.
Your Honor, Justin Smith for the plaintiff, P51886, second hearing, termination of tenancy.
All right, thank you, Mr. Smith. Most importantly, is Destiny Smith here. It's Prescott Smith here. Does anyone reside at 19947 Alcoy Avenue in the great city of Detroit? All right, counsel, do you have any requests for the court?
I do, Your Honor, and I do want to say that I just checked the breakout rooms. I don't see any of the subject defendants in the breakout room either. I'm going to be proposing a submission of a default judgment today with a move date for 10 days.
All right, default judgment is granted. I didn't hear any rent, and I also confirmed that. Tennessee case, defendant must vacate by May 25th, 2023, or a writ of eviction may issue. Thank you, Attorney Smith. You have a great day.
Appreciate the court's time. Thank you.
You're welcome. Ms. Haddad. Good morning, Ms. Haddad.
Good morning, Your Honor. I'm ready on, oh my gosh, I don't even know the case number. Case ending in 4878 with Attorney Lawan.
4078?
4878, Your Honor.
48, having trouble hearing case numbers this morning. Calling case number 233448878, 28 grand versus Alona Wilson and all occupants.
Good morning, Your Honor. For the record, Ronnie Haddad, P84927 on behalf of the plaintiff.
Wilson courtroom. Could you state for the record, please?
Thank you, Wilson. Ms. Haddad, can you put the terms of this agreement on, because Ms. Lawan, it's kind of hard to hear you.
I can, Your Honor. The parties have agreed to enter into a conditional dismissal with 4B checked. The total balance due and owing is $1,201.40. The terms are as follows: that the defendant or a third party on behalf of the defendant will pay the balance owed by June 20th.
That ain't gonna work. That's all right.
By June 20th, 2023. Additionally, the defendant is responsible for her regular rent as of June 1st, her regular rent is $132 a month. And then the courtesy email will be sent to opposing counsel in the event of a default before proceeding pursuant to 4B.
All right, is that your understanding of the agreement, Ms. Wilson?
I had not had a chance to speak with Ms. Wilson. We figured out there was a discrepancy in the ledger. We figured that out.
Yes. Hi. This is Elnoa.
Hello. Yeah, we lost Mr. Lawan, it sounds like. So can you,
Your Honor, what she's trying, if I may, Attorney LaWand, there was a slight discrepancy as to the total balance due and owing. We now have clarified and agreed to what the balance is due and owing, and it's $1,201.40. So we've corrected the ledger, and that is the total balance due and owing.
Okay, so let's see, this is a conditional dismissal for $1,201.48, was it 47 cents?
40 cents.
Right, and 40 cents to be paid by June 20th, 2023. And this matter will be dismissed. It's a conditional dismissal, so 4B is checked. And also your payments of $132 a month must continue throughout the, you must pay that monthly rent as well in addition, but it's not due yet, so it's not within the terms of this conditional dismissal. So does the late fee still apply on the June rent?
No, Your Honor. Late fees will be waived until the balance is owed. I mean, until the balance is paid in full. My apologies.
Okay, so 1,200, and in reality, you have another 132 to pay, Ms. Wilson, but 1201.47 plus June rent must be paid by June 20th. Once that's paid, this matter is dismissed. If it's not paid, or parties don't vacate, then a judgment and a writ of eviction can be filed. Do you understand that, Ms. Wilson?
Yes, I do.
All right, and does your attorney have permission to sign your name on this agreement?
Yes, she does.
All right, well, you're all set. You have a great day.
Thank you.
And
You too.
Thank you, Your Honor. And Ms. Wilson, I will give you a call later.
Okay.
Okay, thank you.
welcome. Thank you.
Right.
Good morning, Your Honor. This is Alan Dyer again, on case 790.
Yeah, Attorney Dyer.
Yeah.
I've got a queue in front of you right now.
Okay, good. Sounds good, Judge. I'll sit tight, just letting you know I'm here.
All right, just put your hand up when you're ready.
Okay, will do.
Looks like everybody's ready to go right now, so I don't want to jump the line. Attorney Coleman.
I believe it. I'm standing on that 100%.
Are you ready? All right, Attorney Fisher.
Yes, I'm ready.
All right, and what matter are you ready for?
The last four numbers, 6473, Elizabeth Kershaw.
Calling case number 2334-6473.
Good morning, Your Honor.
Sharara versus Elizabeth Kershaw.
Good morning, Your Honor. Anthony McClurkin, P74296 for the plaintiff in this matter.
Good morning, Your Honor. Janetta Fisher with Michigan Legal Services representing Elizabeth Kershaw.
Thank you, Ms. Fisher,
Your Honor, we
go
come
ahead.
to a resolution in this matter via a consent judgment as to all occupants with 4B checked. 4B will be June 16th, 2023, Your Honor.
June 16th, 2023. So
That is correct,
all
Your
occupants, this is a termination of tenancy case.
It is, Your
So
Honor.
occupants must vacate by June 16th, 2023. So because this is an all occupants judgment, I'm going to enter it, and whoever submits it can submit it as a judgment by hearing, because all occupants, in lieu of a consent judgment where all occupants will consent. So judgment by hearing, same terms, for all occupants must vacate by June 16th, 2023.
Correct, Your Honor. Thank you very much, Your Honor.
Thank you, Your Honor.
You all have a great day.
Thank you.
Ms. Kershaw, you
Ms.
can,
Hi, this is Sogol.
Yeah, good luck, Ms. Kershaw.
Okay.
Thank you.
And were you telling her, Ms. Fisher, she can log off?
Yes, that is what I was going to say. Thank you, Your Honor.
Thank
You're welcome. Free to go, Ms. Kershaw. Thank you all. All right. Marching down the line with hands up. Attorney Freeman.
Morning, Judge.
I'll call you next, Attorney Coleman, if you're ready. It looks like you caught another hearing. Good morning, Ms. Freeman. Are we ready on 6413?
I believe so, Judge. I have not found the defendant in the waiting room.
All right, Ricky Splight. It's Ricky Splight here. Let's see, let me call this case. Calling case number 2334-6413. This is Charles Peacock versus Ricky Splight.
Good morning, Your Honor. For the record, Attorney Jacqueline Freeman, P 84916, on behalf of the estate of Aurelia Peacock. I am standing in for the attorney of record, Andre Laubeck.
Thank you. And is Ricky Splight here or anyone who lives at 15356 Washburn? No one has appeared to have, no one seems to be here. Mr. Splight doesn't seem to be here, or no one, or anyone who lives at 15356 Washburn. I'm not hearing any response. Counsel, do you have any requests?
It looks like we're just asking for a judgment of possession, no money judgment at this time, and I'd ask for the statutory minimum of 10 days.
All right, default judgment is granted to terminate. This is a termination of tenancy case. That's a non-payment of rent case, counsel.
It looks like we did file that way, Your Honor, but it's been communicated to me that we're not seeking any money at this time. At least not a money judgment.
Without a mutual understanding of this being converted, I would still have to give the defendant.
All right.
On the money.
Per the notes, Your Honor, it looks like there's about 4,000 owed at this time.
Okay, 4,000. All right, and if you submit a judgment, just please submit a ledger if it changes from 4,000.
Thank you, Judge.
That is $4,000, and 4,000 must be paid by May 25th, 2023, or a writ of eviction can issue. Defendant failed to appear and must pay $4,000 by the 25th to redeem this property. All right, you are free. That concludes the matter ending in 6413.
Thank you, Judge. Have a good day.
All right, you too. All right, Attorney Coleman, are you ready? Okay. All right. Attorney Chanis.
Good morning, Your Honor.
Good morning. Is Asia Young?
I'm sorry, go ahead.
Yes.
I've got 6480 and 6479.
Okay, it looks like Asia Young. Asia Young?
Yes, I'm here.
Okay. Did you speak to the attorney for the landlord?
No, not today.
Okay.
If I can do a default on the 6480 and go into a quick breakout room with Miss Young.
That's a reasonable request. Is William Turner Blakely here? All right, calling case number 2334-6480, Silva Property Management versus William Turner Blakely and all occupants.
For the record, Neil Chanis appearing on behalf of the plaintiff, P40079.
Thank you. Does anyone reside on Parkview? 560 Parkview. All right, is William Turner Blakely here? Blakely. Our counsel.
Thank you, Your Honor. We're seeking a possession judgment only. We currently show rent and arrears in the amount of $2,200, costs including statutory attorney fees of $165 for a total of $2,365 with the writ to issue after May 25th, if that amount remains unpaid.
Defendant failed here. The court is issuing a default judgment to plaintiff where defendant must pay $2,365 by May 25th, 2023, or a writ of eviction can issue. The court does have proof of service and defendant failed to appear. All right. That concludes 6480. Please submit a judgment, counsel.
Will do.
And let's see. Let's see if we can see. Adrian Young. Okay. She's named. Thank you, Madam Court Reporter. Let's give you co-host privileges, Attorney Chinas, so you don't get stuck in the breakout room.
Perfect.
I'll invite you to room number 8.
Thank you, Your Honor.
Ms. Young, I'll invite you to room number 8.
Your Honor's Attorney
Thank
Coleman,
you.
I'm ready now.
Fantastic, Attorney Coleman. We were staying busy in the meantime.
As always.
All right, what matter are you
The
on?
case ending in 3657 was scheduled for 10 o'clock.
Early bird. Calling case number 334-3657. This is Anamic LLC versus Kushan Batfield and Jocelyn Wilkins.
Your Honor, for the record, Attorney Frederick J. Coleman, P. 56548, on behalf of the plaintiff. This matter is a land contract forfeiture. I believe, Attorney, there she is.
Yes, good morning, Your Honor. Lauren Namazi, P85424, Michigan Legal Services, on behalf of the defendants. Keyshawn Batfield is present in the Zoom gallery.
Your Honor, today we're asking this matter to be adjourned for 2 weeks. Attorney Namazi, is my understanding, will be placing an appearance, and we need to forward some documentation over to her so we can resolve this land contract.
Okay, 2 weeks from now is Memorial Day, so we'll do May 30th. What is May 30th? May 30th. Ms. Namazi, is Tuesday or Wednesday better for you?
It doesn't matter, Your Honor. The 30th is fine.
All right.
What time, Judge?
Time of those. 9 o'clock, Judge. 9 o'clock.
9:01?
9:01. Let's make it 9:01.
Thank you, Judge. You and your staff have a wonderful day. Attorney Namazi, we get that over to you the next day or so. If not,
Thank you, Attorney Coleman.
Thank you.
So May 30th, 9:01.
Thank you, Judge. You and your staff have a wonderful day. Same to the rest of the gallery. See you tomorrow.
All right. Take care, Mr. Namazi.
Thank you, Judge.
That's what I want to give it to.
Miriam Irby, I'm trying to get you into a breakout room. If you could join room 14. Thank you.
All right. Attorney Phillips.
I have 2, Your Honor, at 9 o'clock. That are ready, settlements. First one is 328.
On case number 2334538, this is OBA Property Management versus Stephanie King and all occupants.
Ready, Your Honor. Dennis Spliss, Land P 30289 for the plaintiff.
One, Your Honor, Ted Phillips, P 35900 for the defendant. And Ms. King is present. Ms. King, do you say your name?
Let's see, Ms. King, where's Ms. King?
Ms. King was present and she did approve what we're about to enter. Your Honor, the parties have agreed to this be a consent judgment. That again, will be dismissed as to the named defendant. It will be against all occupants. There will be a move out date of June the 15th. No resolution of any other claims. Mr. Fleshland, is that an accurate recitation?
Yes, are we converting this to a termination?
Yes. Yes. Convert to termination tenancy. Thank you. I missed that.
All right, so this is converted to termination of tenancy where all occupants must vacate by June 15, 2023, or a writ may issue. Did I miss anything?
We're going to do that by hearing. Is that right, Mr. Phillips?
Oh, I thought it was a consent judgment, but
Well, then we don't have to fool with signatures.
either way, by hearing is fine.
Because it's a judgment by hearing where we're converting this to a termination of tenancy and no objection to the parties where all occupants must vacate by June 15, 2023.
Very good. Thank you, Judge. Thank you, Mr. Phillips.
Mr. Fleshland, you want me to submit that, or are you going to submit it?
I got it. We'll send it in.
Okay.
I'll send a copy to you too.
Thank you. Okay, kind of the other case is 657 with Attorney Johnny.
On case number 22396657, Mutual Property Management versus Sabrina Bowers.
Good morning, Judge Ely Bajani, P 74626 for the plaintiff.
Morning, Honor. Ted Phillips, P 35900 for the defendant who, if she's not in person, if she's not present, it's because she's in a doctor's office and she's not able to come on. Ms. Bowers, could you say your name if you're here? Again, she did approve the terms we're about to put on the record, Your Honor. And in fact, we have a signed, Mr. Bajani has agreed to me signing off on him, for him on a conditional dismissal, which will be submitted to court shortly. The terms of which are that there's $5,892 owed in rent. The defendant shall pay her normal rent of $800 by the 5th of each month and an additional $240 every Saturday until paid in full. There's some additional terms, waiver of 56-day rule. If any payments are missed, then there may be a writ of eviction issued. Other than the very first payment, if that's missed because she is giving birth in the hospital, then she will get a reprieve of 1 week to get caught up. That is the full terms. Mr. Bajani, did I miss anything?
No, that sounds right.
Late payments waived until the commencement of payment plan.
My understanding, is that a fair?
I don't understand the question, Your Honor.
All right. If she pays June rent, June 8th, you know, our late payments being waived. She's paying $240 every Saturday. So I don't see, I have to ask, but it's just, I don't see how it could be enforced anyway, but.
I can have that discussion with my client, and my clients only impose late fees. If they give a grace period, then they only impose late fees if they're substantially late towards a payment plan. So I don't see any being assessed here.
Actually, I missed a term which is written in the agreement that we both signed off on, Mr. Bajani. If all above payments are made timely, there shall be no late fees assessed.
Sure.
All right. As long as they're made timely.
Okay, all right. Court is satisfied. Good luck, Ms. Bowers, and you've already granted the consent that's necessary. So court is satisfied. Thank you, parties.
Thank you, Judge. I have
two other matters that are also ready. I'm sorry, Mr. Bajani. I need to be over to an in-person hearing shortly, though.
Right,
two other matters.
What case were we were just on 657? Yeah. Okay. All
Right,
right,
so two other with Attorney Horka 005. That was the gentleman who called in with his brother in the hospital.
Life support, yeah. Calling case number 22393005, Gerson 7 versus Anthony Cummings and all occupants.
Morning, Honor. Ted Phillips, P 35900 for the defendant.
Good morning, Joe Horka, P 75969 on behalf of the plaintiff.
Your Honor, we had asked for an adjournment of 2 weeks or whatever the court is able to accommodate. based on good cause. That's was stated in the record, or as was stated earlier by the defendant, his brother is in the hospital and in very dire conditions. I would note that Mr. Cummings has made a payment. He has mailed in a payment of 2 months worth of rent since the last time we were in court. It has not been received yet, but it has been mailed. So it is good faith.
Okay, and have the railing, has the railing and the heat been addressed? I know it's not freezing cold, but.
Mr. Cummings, the last time I spoke to him, said it did not. So Mr. Cork, if you could pass that back to your client.
And let's see, does May 30th work?
I'm sorry, is that a, I would prefer a Wednesday if we could. I think that's a Tuesday, isn't it?
May 31st.
We have 6 judges.
Okay, we could do May 31st. 2023. And let's go at 9 a.m.
Okay.
Or 9:01, whatever. However you want to write that down. Okay. So I'll see you all back May 31st.
And the last matter, Your Honor, was 035 with Mr. Herc as well.
On case number 233-44035, Investors Property Management versus Kimberly McKinney.
Good morning, Joe Horka, P75969 on behalf of the plaintiff.
Morning, Your Honor. Ted Phillips, P35900 for the defendant who was present in the virtual courtroom. Ms. McKinney, could you state your name? Your Honor, we would ask as well on this one. I think that both parties agree for an adjournment of 2 weeks if the court can accommodate. Ms. McKinney has made a payment. There has been a payment made of $400 mailed in since the last court appearance. Her monthly rent is $28, so this good faith shown. There are some issues. There's a proposal out, which we're waiting for a response back on. And also we need some information from a Section 8 voucher provider. We would ask for a 2-week adjournment.
All right, does May 31st work at 9:01 a.m.?
That's fine, Your Honor.
All right, that's good. I see in my notes, defendant said they'll pay $300 to landlord in good faith, so she's exceeded the promise. That's good. I'll see you all back. This has been adjourned a few times, but we'll figure it out. May 31st.
Thank you, Your Honor. Sorry, I have to run.
It's all right. Enjoy it. Attorney Matt. Good morning.
Good morning, Your Honor.
Do you have any matter? Okay, you have David Turner. Is David Turner here? Dismissal?
It's a default, Judge. This is the third time he has failed to appear. And I have no problem with having it as to occupants.
Not on default. I only ask that when parties are here, but I mean, that's up to you. That's an option that you are. Okay. That's for you. But I'll call them. Okay. On case number 233-44233, Boydell Development Group versus David Turner and all occupants.
Peggy Madden, P39308 on behalf of the plaintiff.
Thank you. Is David Turner here? Anyone reside at 1652 Court Street? All right, counsel.
Your Honor, I'd ask the court for a default judgment. The amount to retain possession would be $1,644. And that is including court costs.
Okay, 164400. Default judgment is granted. Defendant failed to appear multiple times, and the defendant must pay that $1,644 by May 5th, 2023, or writ of eviction can be.
Thank you, Your Honor. Have a good day.
All right, you too. Dealing. See your hand. Do you have a case ready? Are you requesting co-host privileges?
Your Honor, I am ready on at least my portion of the case at 10 o'clock, ending in 5327.
You said your portion, so it's like if we called it, would the other side be ready?
I'm not sure if the other side would be ready, but it's a motion to withdraw, Your Honor.
Okay, all right, well. Give me one. Is the other side, did you talk to the other side?
I did
Your
message.
Honor, I'm on the other side, Sagati's office.
All right, is there any objection? What's this, calling case number 23345327, this is 3220 Carlin LP versus Sharif Walker. May I have appearances?
Oh, yes, Your Honor. Dennis Splissland, P 30289 for the plaintiff.
And good morning, Your Honor. Benjamin Dietland, P number 85412, on behalf of the defendant, Mr. Sharif Walker, who I believe is present with us in the courtroom.
Mr. Sharif Walker. Sir. All right. Okay, Mr. Dietland, this is your motion.
Your Honor, I'm making a motion to withdraw due to a breakdown in the attorney-client relationship.
All right. I will grant your withdrawal. Does this pose that? All right. Your request is granted. Mr. Walker, do you know what's going on? Mr. Walker.
Yes, sir. Can you hear me?
Yes, you had an attorney, but your attorney has motioned to remove himself from the case. Do you understand that?
Yes, sir.
All right, so you are no longer represented by counsel. You may be able to obtain other counsel, but as it pertains to Mr. Benjamin Dietland, he is no longer your attorney. Is this case
Your Honor,
up for?
Your Honor, this is a case involving termination of tenancy for the property at 15747 North Lawn in Detroit, Your Honor. Our client purchased this property at the tax sale and received a quitclaim deed from the Wayne County Treasurer on October 31st, 2018. Mr. Walker claims that he is the owner of this property based upon a deed he has presented to us from a person named Lydia Williams. However, a quitclaim deed that is dated June of 2019, that'd be after we purchased the property from the county. That deed, Your Honor, on its face indicates that it says, I'll quote it, "Note, this deed is expressly given to release any and all dower rights to the subject property. This act is given free from duress." I don't know what any dower rights have to do with the property, Your Honor. Furthermore, it is the notary on this matter appears to be, we'll say, irregular in that the person who signed it signed by a notary republic. It does not even the proper designation on this document for the notary. The person who allegedly notarized this does not state what county they're commissioned in, what county they're acting in, none of the normal requirements from a notary. So, my conclusion is that Mr. Walker got scammed on this matter, Your Honor, and we're entitled to possession.
All right, Mr. Walker. Do you have any?
Sir. I've been staying, let me take my mess. I've been staying at this property for 4 years. And I've been staying for 4 years. I never got notarized. And y'all telling me that somebody owned my property. I got before pictures. I just left the courtroom. I don't even know how I'm in Renner's court. I just left the whole courtroom. I had a real lawyer. I beat the case. They told me that I won my case was dismissed. 32 Carlin P.O. Box. It's a P.O. box. He don't even want to show up. I'll be on the porch every day, sir. If this was somebody's house, I would have knew it was somebody else. It would have came and said it was somebody else. I know.
No, you know somebody's house is by going to the register of deeds and finding out.
I did.
Race title theory in Michigan, whether it exists, if there's title to the property, and whether the person was first to file that title to the property.
That was me, sir. That was me. That's why they dismissed the case. And it's
hold on 1 second. I don't have both deeds. I'm going to pass this matter and call the rest of these hands that are up, because it's my assumption that they have default judgments or cases that are ready. I address the withdrawal, and then I'll recall this matter to address your issues. If there's a possibility of, seems like you all have exchanged documents. So, I mean, I would like to see the deed. I'm not going to make a determination on competing interests. However, I could look at the deed and make my determination on whether I think it's valid or not.
Still
Or
a house,
make
Your Honor.
based on
Still in houses, Your Honor. He's still in houses. 32 Carlin, Christopher Brown is still in houses. Still in houses.
all right, Mr. Walker. I'll recall this matter and then be ready to present your full argument, Mr. Walker.
I've got to run over to Judge Kennedy, Your Honor. I'll be back.
Okay, yeah, all right, okay. Attorney Dyer.
I'm here, Judge.
Does this thing really keep the same priority? Is the order? I don't know. Okay, Attorney Dyer.
I'm ready to go, Judge. I know the defendant went in to speak with counsel for UCHC. I haven't heard from anyone. However, I've got multiple additional courtrooms to run to here shortly. This case was set for 9:01, and it's a third hearing.
All right, is any recalling case number 2334-4790, Dwayne Williams versus Lexus Lewis.
Good morning once again, Your Honor. Alan Dyer appearing again on behalf of the plaintiff P 54857.
All right, she's in. Ms. Lewis, has anyone from UCAC or Michigan Legal Services spoke to Ms. Lewis or retained Ms. Lewis?
I don't think so, Your Honor, but I'm not certain.
All right,
This is Attorney Fisher.
and thank you, Attorney Fisher. Can I get a confirmation and then
Okay, let me try to send a message.
Walter?
Judge, this is Eli Bijani. Sorry, I lowered my hand and lost my cue, but I believe Walter is my defendant, and we just have a dismissal.
Okay.
Its case setting was 6658, scheduled at 9:30.
On case number 2-239-6658, Mutual Property Management versus Walter Glover.
Good morning, Judge. Eli Bijani, P 74626 for the plaintiff.
Thank you. And Mr. Walter Glover.
Hello. I'm sorry.
Hello. State your name for the record, please.
Walter Glover.
All right, thank you, Mr. Glover. Mr. Bijani, did you all work something out?
Judge, we're dismissing this matter because the defendant has paid in full.
Right, that sounds like grounds to dismiss right there. Dismissed without prejudice. All right.
Thank you.
Mr. Walker, take care.
Thank you.
Mr. Glover.
All right. Thank you, guys.
Have a great day.
Goodbye.
Okay, Your Honor, what I can do, I haven't gotten a response yet. This is Attorney Fisher. I'll just go and talk with Lexus.
Okay. All
Okay.
right, thank
Yep.
you. Mr. Duncan, Michael Duncan, I see you at the hospital, something medical.
Yes, I'm here.
All right, and what matter are you on?
233-46566. Miss Peak.
Okay, it's Michael Duncan? Okay, you're Michael Duncan.
Yes, sir.
You are the landlord, and are the Peaks here?
Yes, I'm here.
And what is your name?
My name is Erica Peak.
All right. Good morning, Ms. Peak. Have you all spoke?
Good morning. No, we have not.
All right, is that your request? Do you want to speak to an attorney? Do you want to speak to Mr. Duncan?
Well, no, I don't need to. It's not a money issue. He just wants his property back, and
Okay.
I have
You don't have to tell me yet. Just I'll allow you all to speak and pop out of the breakout room with the hand up and call the case.
Okay.
All right. She automatically goes to the breakout room because she's on the phone. So I'll invite you to room 10, Mr. Duncan.
Room 10.
Room 10, you should see it on your screen now.
Okay, you're right. Absolutely.
All right. Tasha Martin, are you? All right. Tomlin.
Hi, I was trying to find my the attorney. I was with Cox, but I don't know the other guy's name.
Ms. Tomlin, this is Attorney Horka. I'll pull you in a breakout room.
Okay.
William Gerzak, counsel. Gerzak. Let's see. Counsel, are you ready on your matter? See, Mr. Chanis is. All right, well, let's go with you, Attorney Chanis.
Sounds good.
On case 2334-6479, this is Auburn Hills Property versus Isaiah Young.
Again, for the record, Neil Chanis appearing on behalf of the plaintiff.
Thank you, Mr. Chanis. And is Asia Young here?
Yes,
Ms. Young, were you and Attorney Chanis able to work out some type of resolution?
yes.
All right. Mr. Chanis, would you like to put those terms on the record?
Yes, Your Honor. We've agreed to the terms of a consent order for conditional dismissal. This is a termination of tenancy. We have further conditions under paragraph 3 that says defendants shall vacate the property on or before May 31st, 2023. I explained 4B and also Court Rule 4.201I. Ms. Young gave me permission to sign her name to the consent order.
Okay, and what was that vacate date?
May 31st, Your Honor.
Okay, May 31st, 2023. And in the event you vacate, Ms. Young, there will be no judgment entered or writ filed. But if you fail to vacate before May 31st, there will be a judgment and a writ of eviction filed at the same time in your name, without having to go back to court. So it seems as if, do you understand the terms, Ms. Young?
Yes.
Okay, All right, well, the court is satisfied. Good luck. And if you submit the conditional dismissal, we'll sign it and get it back to both of you all.
Thank
Good
you, Your
luck.
Honor.
Ms.
Have a
Young.
good day.
You too. Have a good day, Ms. Young.
Thank you. You too.
You're welcome. All right. Counsel, Jerzak,
Yes,
did I pronounce your last name properly?
yes, you did.
Okay, all right. I always like to check. All right. Let's see. Is Martin Jimenez here? You all have a solution? Are you in for a default, counsel?
I would be looking for a default.
Okay, I call defaults an hour after, so you still have about 13 minutes.
Okay,
So I'll give parties an hour, and sometimes they pop up in the last 2 minutes, so just gonna stick to it. You're close. You want to keep your hand up, feel free, but
okay, thank you, Judge.
it's your magic number. You're welcome. Ms. Hamoud,
Yes, Your Honor. I have a resolution with Attorney Fisher for a case ending in 6382.
on case number 23346382, S. Burton Management LLC versus Chantel Kennedy.
Nasreen Hamoud, P number 80522, appearing on behalf of the plaintiff.
Thank you, Ms. Hamoud.
Attorney Fisher may be in one of the breakout rooms. But in the meantime, I also have one default to put on the record.
Okay, let's do the default and see who she's talking to. Not gonna stop that right now. So let's call 382. That's your default?
The default is actually ending in 6377.
Okay. 637. So calling case number 23346-377. This is Visar LLC versus Frederick Robinson and all occupants on Guilford.
Nasreen Hamoud, P number 80522, appearing on behalf of the plaintiff.
Thank you. And is Frederick Robinson here? All right, Mr. Booth.
In that case, Your Honor, we're requesting entry of a default judgment with a move-out date that's 10 days away.
One, defendant failed to appear. Default judgment is granted. The termination of tenancy case, no amount to redeem. Defendants must vacate by May 25th, 2023. Or a writ can issue after that date.
Thank you, Your Honor.
You're welcome. That is case 6377. All right, let's see. Giovanna Salisbury. Mr. Moore, will just let me know when Ms. Fisher becomes free. I mean, I'll have an idea, but just remind me if you have to.
Your Honor, you were just calling on Giovanna Salisbury. I've been emailing with me. She's one of my clients. As soon as I get this next one on the record, I told her I would go talk to her.
All right, so I'm going to take her hand down because she has counsel.
Thank you.
Michael Mitchell.
Yes.
Good morning. You have your hand up. Just wanted to see what going in order.
Yes, well, my tenant owes $3,700. I haven't received the paid rent since January. and I wanted possession of the property.
Is Latasha Martin here? Is Desiree Nance here? Calling case number 2334.
Natasha Martin is here.
All right, have you talked, Mr. Mitchell, have you talked to Ms. Martin?
No, no, I haven't. She hasn't gotten in touch with me. I left messages, but I haven't heard from her.
I'm going to invite you all to a breakout room. Ms. Martin, do you have an attorney?
No. No, I do not.
Right. Please accept the invite to breakout rooms and good luck. Mr. Mitchell, okay, good. Attorney Bearshine, and then Attorney Adams, and then Attorney Newman.
Good morning, Your Honor. I just need co-host powers.
I easily accomplish that.
Same here. That's all I need.
All right, you all can chime in on that. I mean, I appreciate the formal and courtesy, but you know, you've got work to do, so.
Thank you, Your Honor.
Well, Attorney Newman,
Yes, Your Honor.
are you ready on Miriam Irby?
Yes, we are. Spoken to Ms. Lawand in the breakout room, and we have a conditional dismissal we'd like to place on the record.
Did we lose? Okay, Ms. Lawand is still here.
I'm
Calling.
still here.
That's right. Calling case number 2334-5278. Oakland Homes LDH versus Miriam Irby.
Philip Newman, P35-499, appearing on behalf of the plaintiff.
Suzanne Stepich Lawan, P48702, Michigan Legal Services, appearing on behalf of the defendant Miriam Irby, who is with us in the courtroom. Ms. Irby, will you unmute and state your name for the record, please?
Hello, Miriam Irby.
Hello, Ms. Irby. How you doing?
I'm all right.
All right. Were parties able to work out a resolution?
Yes, Your Honor. The parties agree that the total rent to retain possession right now is $1,743, costs $159, for a total of $1,902. We will be entering into a conditional dismissal that provides that Ms. Irby will pay $581 a day. She'll pay $500 by May 31st, and then the balance of $821 plus the June rent will be paid by June 15th. We're going to be checking box 4B on the conditional dismissal.
All right. So $581 today, $500 May 31st, and $821 on or before the 5th?
15th.
Okay.
And I'm sorry, Your Honor, and also June rent will be paid by June.
Now, will June rent be paid by June 15th?
Yeah.
Yes.
Okay, all right, okay. Because it makes it a little funny, June 5th and then 15th, so, so 821, so 581.
They're both the 15th. The final payment of 821 and June rent will be paid by June 15th.
Okay, that's cool. And then today is the 15th, so that's
Correct.
pretty straightforward. All right, is 4B checked?
Yes, Your Honor.
Okay.
Yes.
And Ms. Irby,
Yes.
do you understand what's going on?
Yes, I do.
Okay, so this is a conditional dismissal. If you pay $581 today, $500 by May 31st, $821 plus June rent by June 15th. So that's the 15th and the 31st, then the 15th again. This matter will be dismissed. If you vacate, this matter will be dismissed. However, if you do neither, then a judgment and a writ of eviction will issue in your name and can be executed without having to go back to court. Do you understand the terms?
Yeah.
And do you give Ms. Lawand permission to sign your name?
Yes.
All right. Court is satisfied. We'll enter this judgment upon receipt. All right, good luck. Good luck, Ms. Irby.
Thank you, guys. Have a good day.
All right. You too.
Thank you very much, Your Honor.
Thank you.
Thank you, Your Honor.
Is please mute your devices. Attorney Christensen.
Yes, Your Honor. Just seeing if the matter, I believe for 10 o'clock was available, and if you would like to take care of that. Case number 233-46576, Mays versus Thompson.
Okay. There are two Katrina Mays case. Okay, Mays versus Thompson, 6576.
Yes.
I have to call that. Is Katrina Mays here? Hit *6 if you're on a device. Katrina Mays. Okay, let's see. You're representing Curtis Thompson, counsel?
Yes, Your Honor.
All right. And are you on any other matters?
No, Your Honor, just this one.
Okay. Yes, Katrina Mays here. Let's give it a few. I think this is Ms. Mays right here.
Your Honor, can you hear me now?
Absolutely. Are you Katrina Mays?
Yes, I am.
All right. There's two hearings.
Yes.
All right. So Mr. Christensen is here. I want to invite you into a breakout room with Mr. Christensen.
We've already talked, Your Honor, but I'd be happy to talk with her some more if you'd like.
I don't want to talk.
You ready to call this matter? I mean, is it a resolution or is this a hearing?
Unfortunately, it's a hearing. Your Honor, we believe that there's a partial lockout that's occurred where, according to my client, he's not able to get his washer and dryer out of the basement. There's been a deadbolt, according to my clients, on the basement since March.
Case number 2334656, Katrina Mays versus Curtis Thompson.
Yeah.
Can you state your name, Ms. Mays, for the record?
My name is Katrina Mays.
And good morning, Your Honor. Ben Christensen, P86268 with the United Community Housing Coalition on behalf of Mr. Thompson. Mr. Thompson, I believe I saw you in the Zoom gallery. Are you available? And can you unmute yourself and put your name on the record?
I'm sorry, I just muted you, Mr. Thompson. Go ahead.
Curtis Thompson.
All right, thank you, Mr. Thompson. Are you driving, Mr. Thompson?
No, I'm just sitting in my car right now.
Okay, all right. All right. So, let's hold on, let me pull this file. This is 576, case number ending in 6576. We've already called the case. I want to address a few things before we continue. There's proof of service in the file. This is a case, it's a notice to quit for recover possession of property. It looks like parties from the last hearing and parties are here today. So have you vacated from the property, Mr. Thompson?
No, I have not vacated the property. Number one, I had talked to my auntie.
All right, okay. I'm gonna allow you to add more, but I just want to get a few facts down. So you haven't vacated the property. Do you have access to the property?
Have, which is upstairs, yes.
I mean, is that the total area that you're occupying?
No, I can't get access to the basement.
So you don't have full access to the unit?
No.
Your Honor, can I explain why?
Hold on 1 second.
Okay.
And Mr. Thompson, have you ever had full access to the full unit?
Yes.
No.
When my granddad, when it was up under my granddad.
All right, as you as a tenant, were you allowed access to the full unit?
Yes.
Okay, and when did the access end?
May 1st. I'm sorry, March 1st.
And how did the access end?
My auntie put a deadbolt lock on the downstairs door, dealing with the situation between her and my mother.
So is your auntie Miss Mays?
Yes.
Mays? Is your mother occupant of 3244 Claremont?
Yes, she's Audrey Thompson.
Okay. All right. Okay, Miss Mays.
Yes.
Get you, Mr. Thompson, and allow her to speak. She allowed you to speak uninterrupted, so just give her the same courtesy.
Okay, Your Honor. It's my home. You can see on my documentation, it's been my home since 2008. In that, my father had a heart attack a year ago, and now my father's in a nursing home. Curtis Thompson's been staying with my father, not paying rent the way he was supposed to when he was there. It's my home. So after my father had the heart attack, I kept telling Curtis, I want my property back. I want to sell my property. Kept making excuses. So in that, real quick, get out in 30 days. He tried to reach out if he could stay done with it, Your Honor. I just want my possession. The reason I locked it downstairs is when we deal with the next case, we'll talk about that. But what my sister did, me and her had, and she wanted to stay in the property till she got her W-2 forms. And after she got her W-2 forms, she said she was going to leave. February came, she never moved in. So I called her and I was like, okay, what's going on? I don't need to move there now. To make a long story short, she texted me and said, just because I knew what type of person you is, I changed all the locks. I said, you changed the locks? How you gonna change the locks on my home? So I took her text that she sent me and I took it to the police station. And I said, to my home. She had no business going to my home. Her son Curtis gave her keys.
Hold on, Ms. Mays. When you said she had no business going to your home, is she a tenant or an invitee?
No.
She's not a tenant. Is her son a tenant?
The son is, she got mail coming, but she never lived there. I was gonna let her stay there until she got her W-2s. She never moved.
You said she had no business in the home. Was she a trespasser?
Well,
my father let me move in that home. I was helping her and my father, Your Honor. This is Audrey Thompson. Katrina is telling the tale. This is Audrey Thompson. And our father is he's not in a nursing home. He's in a rehabilitation center that he's in. That's not a nursing home that our father is in.
And what we're going to do here is recall this case so that we don't slow down the docket related to everybody else. And then we'll get to the bottom of this toward the end of the hearing. So Mr. Thompson, if you have to go somewhere, you have a few minutes to get your travel in. If not, just sit tight, but there are a few that are ready, and then we're not going to rush through this, and we'll take the time we need. So
okay, thank you.
It.
Honor, can I just clarify? I don't know if this was clarified. I'm sure it was, but I believe all occupants is the Miss Thompson. She's in the other case with Miss Mays. I think this is a duplex, so I just thought I would inform the court of that, if I'm not mistaken.
Okay, thank you, because I put 4-7 Well, 575?
I'm 575.
Yep.
And I have an attorney, Your Honor.
I'll set that aside. 575, and who's your attorney?
My attorney is Miss Kiana Bonds, and she has
Oh,
all
yeah, I
my
see her.
text messages from United Housing and Coalition.
And where is Ms. Bonds here today?
I believe she's in Judge Kennedy's courtroom right now, Your Honor.
Okay, so.
And she has all my.
All right, so Mr. Christensen, can
Yes.
you assist the court with letting us know when Ms. Bonds is here and when
I can try my best, Your Honor. I have I think 6 hearings in Kennedy that I'm about to have to appear for.
okay. So when you all are going, just come back can you come back before noon?
Come back before noon. Okay, Your Honor, will do. I'll let Ms. Bonds know.
Try to
Okay.
get Ms. Bonds here before noon, and if
Okay.
possible, not just ask Judge Kennedy, can you let us know? We have an afternoon, I can put it over to the afternoon, but I prefer to just knock out as much as possible.
Okay, we'll do our best, Your Honor. Thank you.
You're welcome. Thank you. All right, so you all sit tight. I'm gonna place you on mute. I'm gonna lower your hands. Let's see. So we can sort some of this out. And Attorney Jerzak.
Okay.
Yes. Yes, I'm here.
As promised. Is Martin Jimenez here? Calling case number 2239-6331. This is Bernard Lazaro Vasquez versus Martin Jimenez and all occupants.
Good morning, William Jerzak, P 73185 on behalf of plaintiff Bernardino Lazaro Vasquez.
Swipe left. All right. Thank you, counsel.
Your Honor, this is a termination of tenancy case. I did have to file an amended summons when this was in front of Judge Kennedy because the address was spelled wrong. That's been filed. It was served on April 5th of 2023. There was a first appearance on 5/1 of 2023. So this is the second appearance with the correct summons.
Okay.
We ask for a default judgment with May 25th a vacate date.
All right. Does anyone reside on Lorenz? Never seen this street before. 1266 Lorenz in the city of Detroit. Our counsel, you're asking for a default. Defendant failed to appear. Default judgment is granted. It's a termination of tenancy case. So defendants must vacate by May 25th, 2023, or a writ may issue.
Thank you, Judge.
Sure. Mr. Move. Attorney
Yes, Your
Dyer.
Honor. I have that one case that's remaining, and we have a resolution to put on the record with Attorney Fisher. That's a case ending in 6382.
On a roll this morning. Calling case number 2334-6382. This is S. Burton Management LLC versus Chantel Kennedy.
Nasreen Hamid, P number 80522, appearing on behalf of the plaintiff.
Good afternoon, Your Honor. Janetta Fisher with Michigan Legal Services, representing Chantel Kennedy.
Thank you, Ms. Fisher. And Ms. Kennedy, Ms. Kennedy, can you state your name for the record?
Chantel Kennedy.
Thank you, Ms. Kennedy. and you were here since 8:30, like a lot of you all. All right, would you like to put the terms of the resolution on the record?
Yes, Your Honor, we did work out a resolution. It's my understanding that we have agreed to a move-out date of June 16th, 2023. That'll be via a judgment by hearing against all occupants, with Ms. Kennedy's name being removed as a named defendant. Is
That's
that
correct. Oh, sorry.
That's okay.
And Ms. Fisher, is anything else? Is anything missing from this agreement?
No, Your Honor, everything is correct.
Okay, the court enter a judgment by hearing where all occupants will vacate by June 16th, 2023. The case was originally filed in Chantel Kennedy's name. There's a removal of her as a named party and an entry of all occupants where all occupants must move before June 16th, 2023, or a writ may issue. Thank you, parties.
Thank you, Your Honor.
Thank you, Your Honor.
Welcome, Ms. Fisher. Is Micah, let's see. All right, Attorney Dyer, are you ready on yours?
I'm not sure, Judge. I haven't heard anything more.
Are you on the case for Lexis Lewis?
I am.
Okay, we need to go to a breakout room. I have
That's
talked
fine.
to her. Okay,
Okay.
so
Well, both have breakout privileges, right?
I do not.
I do.
Okay.
Okay,
All right.
I will try to move you to a breakout room.
Great, thank you.
You should have them now, Attorney Dyer, but I'll leave it up to you all as
Thank you.
attorneys.
Judge
Oh,
Sabree,
yeah.
can I have co-host privileges, please? Thank you.
All right, Attorney Christensen, is your hand intentional? Infinity Cannon, skipped over you.
Yes, I'm here.
All right, you have your hand up. I was wondering what was going on. How can we help you?
I've been waiting since 10. My appointment was at 10. I don't know how it's going. Like, is it going in order or?
Mr. Horka, would you like to speak to Ms. Cannon? Ms. Cannon, do you have an attorney?
Judge, I chatted Ms. Cannon. I tried to move her to a breakout room. I was unsuccessful.
All right, Ms. Cannon, please look on your screen. The attorney for landlord has attempted to invite you to a breakout room. I think it's room number 5. I'll do a fresh invite and invite you all both to another room so she gets another prompt.
Okay.
You'll be prompted to move to room 17.
Is this Mr. Dyer? Is this Mr. Dyer?
No, do you need to speak to Attorney Dyer?
Yes, I do. This is Attorney Fisher.
Okay, 4780, let's see. Let's get you in, what room is Attorney Dyer in?
He's in the main courtroom. I wasn't able to move him.
No, he looks like he's in. All right, Mr. Marquez. And then I'll get.
Yes, sir.
Still hanging around this.
Man at 021 with Mrs. Steppich Salisbury. It must be in a breakout room.
Judge, can you confirm what court breakout room Alan Dyer is supposed to be in? I seem to be in with somebody else.
Okay, yeah, this room 8, it looks like Attorney Fisher zoomed in.
Great, I'll go there now. Thank you.
Attorney Fisher.
Yes.
here.
Okay, let me go to room 8. I'll go there now. Thank you.
Perfect. Thanks.
Okay.
Who's this call-in number?
I have no idea.
All right, I'll zoom her back out.
Okay, thank you.
All right,
Excuse me, Judge Sabree.
yes.
This is Miss King. I had appointment at 9, but
You're
I had got
free.
into
Go ahead.
I got into an altercation and they took my phone, but I'm back now. And was it handled?
Yeah, it was handled. Let's see, what happened with Ms. King? Because both parties, you had an attorney, Attorney Phillips was here on your behalf, so let's see. I'll just review, see what happens here, Paige, real quick.
Hearing judgment, Judge.
The hearing judgment, I think it was a move out date, so it's probably
June 15th, Judge.
Yeah, it was a June 15th move out date.
Okay,
Occupancy.
thanks.
Yep, it was, Judge.
Okay,
Dismissed
so
her.
your name, it was dismissed to your name. It was entered as all occupants for all occupants by June 15th, 2023.
Okay,
Good luck.
thanks.
All right, we're okay, Mr. Juan is in room 13, Mr. Duncan, and then Ms. Pagani.
Yes, sir. I'm here.
Were you able to speak to the other parties?
Yes, sir. I talked to Miss Pete and she can't find a place. So what we're gonna do, she's gonna give me $22.50 for the 3 months.
Resolution, I'll call it shortly.
Okay, sir. What?
No problem. And Ms. Pagani.
Morning, Judge. I'm here on 651. It will be a default. Hearing was at 10.
Let's get you taken care of. It's a 10 o'clock default, 651. Short, sweet, right here. Calling case number 233444651. This is Deutsche Bank National Trust Co. versus all occupants at 220 Richton Street. Who lives on Richton? Anybody on Richton? All right. Counsel, do you have any requests for the court?
Yes, good morning, Judge. Solgo Plagany, P 69690 for the plaintiff. This is a summary process following a mortgage foreclosure sale. Redemption has expired. No redemption was made. My client holds title to this property. This is a second hearing. Service was made on April 22nd of 2023 by Officer Carlton Carter, asking for a default judgment with a writ to issue on or after May 25th, 2023.
Granted.
Thank you, Judge. We'll get that faxed over.
You are welcome. Have a great day.
You as well.
All right. Attorney Bonds.
Your Honor. Yes, Your Honor.
Good morning.
Good
Were you
morning.
just requesting breakout privileges?
Yes.
Okay. I'm gonna put your hand down.
Thank
you. Looks, you and Mr. Christensen have kind of like sibling cases in a sense. So
yes.
If you're ready to be called, I'll call your case. I'm gonna call his case and your case at the same time. Mr. Christensen, what's the time looking like? Do you have to go to Kennedy still?
I am in Kennedy, but my matter is not being called yet.
All right, so we'll just see how it goes. We'll adjust accordingly. So I have a few more I need to call.
Okay.
But let's see. Attorney Adams. Mr. Duncan, are you do you need 20 minutes or you need
No, sir, we're ready.
Okay. All right, let's get you. And Attorney Adams, are you ready to call?
Yes, I'm not sure if the defendant is here, so for 574.
Let's call the address out, see, just in case they are. Get
Yes,
started.
I'm here.
Okay, I'll send you, I tried getting into a breakout room with you, so I'll send you an invite and we'll be back, Your Honor. Thank you.
Well. All right, Michael Duncan. Calling case number 2334656. This is Michael Duncan versus Erica, Michael, Amari, Tyree, and MacArthur Peak.
Yes.
State your name for the record.
Michael Duncan.
Thank you, Mr. Duncan.
Mhm.
And is Erica Peak here?
Yes, I am.
All right, can you state your name for the record?
Erica Peak.
Thank you, Ms. Peak. Thank you all for your patience. Mr. Duncan, first and foremost, are you the owner of the property located at 18073 Cardoni?
Yes, I am.
Okay, and Ms. Peak, are you still occupying that property?
Yes, I am.
All right, were you all able to work out some type of agreement?
Yes, sir.
Okay, and what are the terms of that agreement?
So she should have 2250 on the 19th of this month, this coming Friday. And also when the main drain bags up, he pulls out things that don't supposed to be in there, she's gonna pay. That's what the issue was. And also
you said she's gonna pay?
Yeah, we had a dispute about the drainage, you know, kept pulling out female things, hair, whatever.
Okay,
But
so
the main thing, Your Honor, is
drain or the main drain's causing it to back up.
yeah.
And
So we got it
so
understood. I'm
she's
sorry.
is Ms. Peak gonna cover the expenses? Is that what you're saying of the drain clean out or something?
Yes, sir.
And do you know what those expenses may be?
They generally run about $180, $160, $180. I mean, it's taken care of now, Your Honor, but for the future.
Okay.
And also, we're gonna go a year, and then hopefully she wants to buy the house, and I don't have a problem with that.
All right, well, make sure you all get an attorney. Make sure you get an attorney or get some type of legal advice.
Yes, sir.
You all draft up a legitimate land contract, so both parties have what they need and both parties have what they're paying for. So, 2250. How much is? So are we going to convert this from a termination of tenancy to a non-payment of rent?
Yes, sir.
All right, we're going to convert this to a non-payment of rent from a termination. Whereas, Ms. Peak, you'll pay $2250 on or before June 19th.
Okay,
Are you in agreement with that?
I am.
Now, how much is her rent, Mr. Duncan?
Sir, it's May 19th. Her rent's $750.
Okay. May 19th. May
Yes.
19th.
Yeah.
The court's minimum amount of days is 10 days. So May 19th, we can't even do.
Okay.
May 25th is the earliest we can do. So we'll do 2250 by May 25th, 2023. And in the event you all work something else out, I'll leave it to whatever's on the four corners of whatever document you all wrote it on.
Okay.
But, as it stands right now, you don't have a land contract, Ms. Peak. You have $2,250 that must be paid by May 25th, 2023. If that's not paid, a writ of eviction, well, a judgment A judgment will be entered today, but a writ of eviction can be applied for on May 25th, 2023. Now, will partial payment prevent you from filing an eviction, Mr. Duncan?
If you could have.
No, man, I really don't want to do that, Judge.
Okay, is this a question, is a yes or no question? And it's not gonna.
Yeah. I don't want partial payment, sir.
Okay, so I say that because if 2,200 is paid, Ms. Peak, technically, it may not be practical that he files an eviction, but he would have the legal right if $2,249 was paid, and you only owe $2,250. So yeah, that's $1 probably won't happen, but if it's $350 and you think, hey, I paid him, I'm not gonna get evicted, but he has every legal right by checking that box on the judgment that partial payment will not prevent eviction. We're not in person. If we were in person, I would show you the judgment, but I don't have you all in front of me. So those are the terms. $2,250 by May 25th. Partial payment won't prevent eviction. This is converted from a termination where it was just a move-out date to now you can redeem your property and stay in your property beyond that date. Are we all on the same page?
Yes, we are.
All right. Does Mr. Duncan?
Yes, sir.
Mr. Duncan, I want you and Ms. Peak to at least see the same document. If you have to take a picture of it and text it to her, whatever you all need to do to see the document. Now, Ms. Peak, do you give Mr. Duncan, assuming you've reviewed this document, do you give him consent to sign your name?
Yes.
Okay, so I still want you to send that document over to her, Mr. Peak. But if you sign both names on that document, I know she's giving you consent, so long as you agree to make sure she reviews it. So tell the court you'll make sure you send it to her. Are you going to send her this document?
Yes, sir. I sent it to her, get an opportunity to sign it, sure.
All right, so practically, if you sign both, that's fine. I just want her to see what you're signing.
Okay.
Okay, all right. Well, good negotiations, and that concludes this matter. So this matter is converted to a non-payment. She can redeem the property for $2,250. Now, is June okay, yeah, and that's by May 25th. So we're not talking about June. You all get something clear in writing, but good luck, Ms. Peak. See, you've got a few more people in the house with you, so good luck, and I'm assuming happy Mother's Day.
Thank you.
You're welcome.
Thank you, Your Honor.
You're welcome. Thank you, Mr. Duncan. All right. So, Mr. Marchese, is that a yay on your matter? We're about to go into hearing mode.
I'm chatting with Ms. Steppich now, so we'll probably go to breakout room. I don't know. I don't even believe this case has been called. So, I mean, whatever you want to do.
Don't have too much when I get around. Giovanna South, oh, if she's talking in the breakout room, okay. Ms. Lewan, Attorney Lewan.
Ms. Lewan, sorry. Yeah,
Yes,
she just
Your Honor.
invited me to breakout room 10. Do you want me to go or do you want to call it?
Yeah, Ms. Lewan, tell me when you're ready, because I know you're moving from case to case, so I'll let you keep working until you are ready, and then I'll call it.
I'm
Mr.
ready to
Martin.
talk to Attorney Marchese. See if we can't figure what's going on here.
All right, Attorney Adams, you're still waiting on something?
Actually, we need a 2-week adjournment
Okay, calling case number 233-44574, Universal Real Estate versus all occupants at the property located 18443 Braille Street.
Valerie Adams, P73324 on behalf of plaintiff, Universal Real Estate.
All right, thank you. And Roland Reason, is that your name, sir? Roland Reeves?
Yes,
What's your last name?
reason.
Okay. I read it right on this file. Okay, you all need a brief adjournment. I have May 30 and May 31st. Is that enough time?
Yes, May 30th will work. Unless you got June 1st.
I have June, let's see, do I have June 1st? June 1st, Judge. Nothing on June 1st, Judge. Nothing on June 1st.
I'll take the 30th. I'll do the 30th.
Okay. May 30th, oh no, we can do June 1st. We can do June 1st. All right, so let's do June 1st at 9:01.
Okay, thank you.
So, Mr. Rowland, Mr. Reason, I'll see you back June 1st at 9:01. If parties haven't resolved it in between.
Thank you, Your Honor.
Welcome, have a great day. Take care, Attorney Adams. Right, and all right, Attorney Christensen. Oh, yeah. Let's recall this case. My party's ready on Alexis Lewis. Alexis Lewis.
Plaintiff's ready to go, Judge.
Where is that? No doubt to that, counsel.
Okay.
Okay.
You can sign my name.
Ms. Fisher, are you ready?
Well, I did talk to my client, Your Honor, so I'm not sure if she's willing for me to sign her name to the judgment or not. She's back and forth. I'm ready as ready as I'm going to be.
Yes, Ms. Fisher, you can go ahead and sign my name. I'm ready.
Okay. All right. Thank you, Lexus.
You're
We are ready,
welcome.
Your
Thank
Honor.
you.
On case number 233444790. This is Dwayne Williams, MSC Williams Global Enterprise versus Lexus Lewis and occupants on Hayden. May I have names for appearances, please?
Certainly, Your Honor. Good morning once again. Alan Dyer appearing again on behalf of the plaintiff, P54857.
Good morning, Your Honor. Janetta Fisher with Michigan Legal Services representing Lexus Lewis. Ms. Lewis, please state your name for the record.
Lexus Lewis.
Thank you, Ms. Lewis.
You're welcome.
All right, we held up, go ahead.
Judge, we did speak in a breakout room briefly, and I believe, and Ms. Fisher will correct me if I'm wrong, that the terms of understanding are simply there'll be a judgment entered via occupants only. There'll be no named defendants. They'll be dismissed from this action. And the move out date will be extended from the 10-day statutory minimum to June 29th. And that I'm not sure if that's going to be a consent or a judgment via hearing.
Your Honor, Your Honor, those terms are correct, and I did speak to my client about it.
Okay, so the court is going to enter a judgment by hearing where all occupants, where the named parties will be removed from this case, specifically you, Ms. Lewis. You're going to be removed as a named party. You won't have a judgment in your name. Plaintiff's attorney agreed to accommodate you on that, as well as some additional days. So June 29th will be your move-out date instead of the statutory May 25th date. Are you in agreement with this?
Yes.
Okay, because this is an all occupants judgment, the court will enter this as a judgment by hearing. I see that all parties are in agreement, so that's a determination I think will work out. So I'm going to enter this as a judgment by hearing. I still would like you, Attorney Dyer, to submit it, but all occupants must vacate by June 29, 2023, or writ can issue.
Will do, Judge. Thank you. And everybody have a great day.
Thank you, Your Honor.
Thank you, Ms. Lewis, for your patience. Thank you, Ms. Fisher. Thank you, Mr. Dyer.
Thank you.
All right. It's Micah Mitchell. Our party's ready on Michael Mitchell versus Latasha Martin.
Yes, Your Honor.
On case number 23346409. Michael Mitchell versus Latasha Martin and Desiree Nance.
Yes, Your Honor. Like I said earlier, the occupant owes me $3,700, and I haven't heard since.
Can you state your name for the record?
Michael Mitchell.
All right, is Latasha Martin here?
Yes,
And can you state your name?
Latasha Martin.
All right. This is a complaint for non-payment of rent. What's the monthly rent?
$875.
And when was the last time rent was paid?
I think in March.
January 1st.
January was paid in full?
Yes.
So February is owed?
Yes, February, March, April, and May.
All right.
Excuse me, Your Honor, there's too much noise in the background.
She's probably at a school. You at a school?
Yes, I'm at work.
Lunchtime?
Yes.
All right. Can you
I
mute?
stepped outside though.
All right. So just mute for a second, and then we'll ask you to unmute. So then, in the meantime, we can just we can keep it quiet. Thank you. All right. So $875 per month for 4 months. Ms. Martin, do you agree with that?
Yes.
Okay. All right. And what is that amount total? Is there a late fee assessed?
$50 every month.
So $875 times 4 plus 200.
Correct.
All right. And what is that number?
Well, it was $875 plus 50. That's $925 times 4 months, so it would come to $3,700.
Guess that's, yeah, it's the same math. All right. So when can that, Ms. Martin, when can that be paid?
I can pay by the end of the month.
All right, Mr. Mitchell, how much time are you willing to give Ms. Martin to make that payment?
If it's going to be paid in full, I'll give her to the end of the month.
Okay. So, Ms. Martin,
yes.
You don't have to unmute. I just want you to listen up. So he agrees that he can give you until the end of the month to make this payment. So the court will enter a consent judgment. That's where parties agree that defendants will pay $37,300 by, let's see, May 31st, 2023, or a writ can issue after that date. Now, will partial payment prevent an issuance of an eviction? So if Mr. Mitchell, if Miss Martin paid $3,600 or $2,900, will you still be seeking a writ of eviction?
Yes.
Okay, so partial payment won't prevent an eviction. In the event he doesn't want to file it, that's up to you, but that's a term on the judgment sheet. We're not in person, so I want you all to be aware of that box and make sure you check it on the judgment. Because you're gonna have to submit a judgment, Mr. Mitchell, to the court, a consent judgment. Now, Ms. Martin, you're agreeing to this. There aren't any other terms that you're agreeing to. Do you give permission to Mr. Mitchell to sign your name?
Yes.
Okay. And understand you're not represented by counsel. So MCR, Michigan Court Rule 4.201I allows for you to file a motion within 3 days of this if you want to set it aside. It has to have some legitimacy to it, but if it's legitimate and it pleads something pleads some relief that the court can grant, it will grant it. But in any case, $3,700 by May 31st. After that, a writ could issue. Anything else? Get it in writing from Mr. Mitchell, and make sure you get it in writing. So I'm going to enter this consent judgment. Mr. Mitchell will be waiting for it, and good luck to both parties.
Thank you, Your Honor.
You're welcome. Good luck, Ms. Martin.
Thank you.
Welcome. Is Davina Hayes here? Is Janita Tomlin? Were you able to talk to Attorney Horka?
Yeah, we may need an adjournment on that one, if you're able to call it now.
Calling case number 233-44044, Detroit Renaissance Fund versus Janita Tomlin and all occupants.
Morning, Joe Horka, P75969 on behalf of the plaintiff.
Ms. Tomlin?
Yes.
Can you state your
Janita
name?
Tomlin.
Thank you. All right, shows that this case was adjourned to today. Not sure why, but how much time do you need?
Yeah, under just a week or two. Attorney Cox's office has not heard back from their client whether the payment plan that was proposed by Ms. Tomlin has been accepted. I can't proceed this morning without that information. I'm asking for a short adjournment.
Okay, it's May 30th or May 31st better?
It's up to you, Ms. Tomlin.
The 31st is fine.
Okay. Court finds good cause to adjourn this matter to May 31st, 2023 at 9:01 a.m.
Thanks, Judge. I do have another one ready with Ms. Cannon ending in 578.
All right, you're free to leave, Ms. Tomlin. I'll see you back on the 31st.
Okay, thank you.
You're welcome. Let's see, which one, Mr. Hart?
578 at 10 a.m.
Calling case number 233-44578, Rondo Investments LLC versus Infinity Cannon.
Morning, Joe Horka, P75969 appearing for the plaintiff.
Thank you. Is Infinity Cannon here?
Still here?
Yes.
There.
All right, can you state your name?
Infinity Cannon.
Thank you. All right, counsel.
And this is a non-payment of rent case. Ms. Cannon has agreed to pay her balance on or before May 31st. We'd ask for the court to enter a consent judgment upon presentment for $2,655. That total includes the court costs.
All right, this is a consent judgment where you, Ms. Cannon, agree to pay $2,655 on or before May 31st, 2023. If that happens, a writ of eviction will not issue. This case is, your judgment will be satisfied. In this case, it will just be resolved. In the event that payment isn't made, a party's don't vacate by May 31st, then a writ of eviction can issue. This is a consent judgment. You don't have counsel, so Michigan Court Rule MCR 4.201I applies, where you can file a motion if you need to set this aside if you realize this was not what you wanted to do. In any case, this is a consent judgment. We're not in person. Mr. Horka will likely draft it up consistent with the terms, and I took notes on my file, so I know the terms as well. Do you give him consent to sign your name on this document?
Yes.
Okay. Court is satisfied. Did I miss anything?
No, Your Honor.
All right. Good luck, Ms. Cannon. Thank you for your patience. This concludes this matter. Case number ending 4578.
Thank you. Have a good day.
All right, you too. All right. Let's see. Recalling case number 23346575. This is Katrina Mays and all. Well, no, I'm sorry. I never recalled that case, but we'll call it Katrina Mays and all occupants. This is Attorney Bond's matter.
Your Honor, I will not be putting on my camera because I have low bandwidth right now.
Okay.
Oh, there goes Ms. Thompson. I was actually trying to speak with Ms. Thompson.
Okay, Ms. Thompson, I think is in the red shirt.
Yes, ma'am.
Galaxy A03S. So if you need to speak to Ms. Thompson, feel free to speak to her, and then let me know when you're ready. Just put a hand up.
Thank you.
You're welcome. We're gonna mute you, Ms. Thompson. This is feedback. All right, and I'm gonna wait to recall Katrina Mays versus Curtis Thompson until I get an understanding of the other case. Kimberly Black. Calling case number 23346271. This is Kimberly Black versus Brittany Williams and all occupants. Ms. Black, can you state your name for the record?
Kimberly Black.
All right, and did you have an opportunity to speak to Ms. Brittany Williams?
There was no need to speak with her. The reason why you asked for me to come back was because you need to check for the validity of the quitclaim deed.
Okay, so you didn't have.
The court appointed attorney last week on May 8th couldn't find the information, even though I provided the Lieber number and the page number, and I called back down to the Register of Deeds. And they said they couldn't figure, they don't know why it wasn't able to be located, because it is indeed registered as of November 23rd, 2022.
All right, so who's the attorney on the other side?
Ms. Bonds.
Why didn't you say anything when I called your name?
I'm sorry. I was trying to unmute my phone. It was acting crazy.
Okay. All right. So Ms. Bonds has one or two cases. I'll recall this, but were parties able? Did you submit your deed, Ms. Black, to Attorney Bond?
Last week, I submitted that, because you asked me to put it up to the screen, and she, for some reason, was unable to locate it at that time. And then that's when you asked for it to be recalled today.
Okay. All right, okay. Well, you'll definitely have to speak to Attorney Bonds at some point, so looks like you need to, I'll recall it, it's not an issue. So Katrina Mays, Curtis Thompson, Mr. Marquez.
Yes, John, I think we're ready.
All right, I'll recall your matter, Mr. Black.
Hooray.
Calling case number 233-44021, Central Towers versus Giovanna Salisbury.
Here, my KZP 75872, plaintiff.
Suzanne Steppich Lawan, P48702, Michigan Legal Services, on behalf of the defendant Giovanna Salisbury, who is with us in the courtroom. Ms. Salisbury, will you unmute and state your name for the record, please?
Giovanna Salisbury.
All right, thank you, Ms. Salisbury. Were parties able to work out some type of resolution?
No, Your Honor, I don't think there's possible in today's time frame to reach a resolution. So as much as my client does not want to adjourn this case, I think that Mrs. Luan and I will agree to a June date for an adjournment.
Oh, and a good in-person day.
An in-person date.
Yeah.
All right. Is it a June 1st or 2nd? Because those are digital days, but.
No, next week. Could we do at least, sorry, could we do at least the next week, at least?
Okay, let's do June. What day works best for you, Attorney Luan? Mondays and.
Monday, Wednesday, or Thursday, Your Honor.
Monday, Wednesday's Flag Day, Donald Trump's birthday. Dad's birthday.
How about June 8th? I guess wouldn't be the end of the world if you have that.
June 8th looks available, counsel. June 8th, 9:01 a.m.
Thank you, Your Honor.
You're welcome. All right, I'll see you all back June 8th.
Great. And Giovanna, you're done. I'll be in touch.
Okay.
All right. All right, have a great day, Ms. Salisbury.
You too.
You as well. All right. That one didn't get resolved today, but resolution coming in the future. How are we doing on James Chalmers? For Sean Thomas. After that,
Your Honor, have we called case ending in 5498? It was at 11 o'clock.
Bria Jackson? Nope. We can. Is Bria Jackson here?
I haven't seen her, Your Honor. She may be on one of the devices that was not named.
I've been here.
Okay.
All right.
Yeah, I got about 5 more minutes on my break.
Your Honor, can I just take her into a breakout room real quick?
Yeah, okay. Can you do it?
Yes.
Okay, all right. And
Thank you.
good luck. I'll call as soon as you all are ready. So Ms. Jackson, you'll get invited into a breakout room. It'll just be you and Ms. Haddad speaking. And then we'll call your case when you're ready.
Okay.
All right. And let's see, Motor City relocation, Doug Brett.
That is my client.
Okay, all right, well, good. Good morning.
Good morning.
We don't have that many cases left, so let's do what we can do. I'll call Attorney Christensen. Did he just leave? Yeah.
Your Honor, I know he's been in a couple different courtrooms this morning, so he may have had to duck out.
Yeah, my timing's bad with that, these cases. Okay, no, they're doing what? Okay, I see what's going on. They're in room 11. Got James Chalmers. Did we do James Chalmers?
Nope, we have not done it yet.
Got Bria Jackson. Just discuss that one. Hayes. Sean Thomas. Mr. Santiago. Where did Mr. Santiago go?
Your Honor, he's also back and forth between a couple of courtrooms.
You know if Sean Thomas is here?
I do not. I can look.
Mr. Thomas. I know Galaxy AO3S is not Mr. Thomas. All right, Mr. Sagati, are you ready on, Mr. Flesson, are you ready on 327?
I think so, Judge.
I think that's the only case we can call. So calling case number 23345327. This is 3220 Carlin LP versus Sharif Walker.
All righty, Your Honor. Dennis Flesland, P30289 for the plaintiff.
All right. Thank you for your appearance. May I have your appearance, Mr. Walker?
Sharif Walker.
Right, thank you, Mr. Walker. And this is a recall. Mr. Flesland, Mr. Walker, are you contesting the validity of, all right. So we're both parties able to review each other's deeds.
Yeah.
Yes, Your Honor. We have a copy of Mr. Walker's deed. There's also been some other litigation regarding this matter over the years, Your Honor, and I'm trying to put my finger on the orders that were entered in that case. There were two quiet title actions filed in Wayne Circuit Court. One was filed by the plaintiff, in this case, Carlin, that ended up in a default judgment. I'm trying to put my finger on that judgment. There was another one filed by Mr. Walker.
Wasn't notified, sir.
Hold on, Mr. Walker. We could barely hear you with the mask on.
I said wasn't notified. That's why I was a defaultment.
Your Honor, default judgment was entered in that case. There was another case that Mr. Walker filed against Carlin in 2022 that was dismissed for non-service according to the Wayne County records. If we could pass this, I'm going to try to find a copy of that judgment, Your Honor.
All right, okay. That's great.
I can't even hear you, Mr. Walker.
I say it's just so frustrating, sir. I apologize, Mr. Adams. I apologize. I'm talking judge, but it's just so frustrating when people trying to steal your house. And I went to court. I had a judgment, and I don't know why I'm in rental court. And they can't even show me the lease that Mr. Carlin pillbox signed or anything. I've been on
He doesn't understand what he's talking about, Judge.
I don't understand what you're talking about.
All right. Well, you still need some time. You need some time to, do you want another date, Mr. Flesland? Or do you just need some time?
Oh, give me a few minutes here, Judge, if I can find that judgment.
All right, Mr. Walker. Mr. Walker, do you have a case number for those other two cases?
No, sir.
I've got the numbers, Judge. I've got the numbers, Judge.
You're just trying to dig them up. All right, so I'll pass this matter and let me know.
Can I say
Let me know
one
when
more?
you.
Can I say one more word, Your Honor?
Absolutely.
One more word. Trying to understand. Since we've been here in this same, well, I didn't see you last time, Judge. I just went into courtroom and I just had a judgment. I'm trying to understand why it was dismissed and why am I back in the same thing? Trying to understand. I just don't understand. People don't have money to keep paying for lawyers. That's why I'm not in here with a lawyer.
This lawyer, their lawyer is available, I think, but your lawyer wanted to.
That's all the public lawyers, sir. They wanted me to go to the judgment. They wanted it, I don't agree.
Your Honor, he was represented by attorney O'Day Marawai in these cases.
All right, well.
Let me get the full picture here, Judge. We're not making any progress.
Okay. All right, you guys sit tight, Mr. Walker. And let's see, if we don't have anything ready. Oh, Mr. Dad.
I'm ready, Judge.
Okay. Calling case number 2335498. This is MotorCityRelocation.com versus Bria Jackson.
Good afternoon, Your Honor. For the record, Rania Haddad, P84927 on behalf of the plaintiff. My client is also in the Zoom gallery under Motor City Relocation.
Doug Bretsch Jr. here.
All right, thank you, Mr. Press Jr. All right, were parties able to work out some type of agreement?
Yes, Your Honor. Ms. Jackson is also in the Zoom gallery, and I had an opportunity to speak to her. And the last hearing, we were going to obtain a judgment by hearing. However, there was an issue of the freight elevator not working. So parties have agreed to enter into, if the court would oblige, a judgment by hearing as to all occupants. Ms. Jackson will have until June 20th to pay or vacate. The caveat is that if the freight elevator, which should be fixed within the next 30 days, is not repaired, then she will have until 1 week, which is 7 days after the elevator is repaired, to move out. She has indicated to me that she has already started moving her belongings. It's just a matter of getting the large furniture out. And so those are the terms that we discussed and agreed upon.
All right, so June 20th, 2023. But if we get to June 20th, 2023, and the elevator isn't repaired, she will have 1 week after freight elevator. After freight elevator is repaired.
Correct. And also we will put her on notice once the elevator is repaired.
That was my next statement. It's like, make sure you provide her with some notice so then you can pinpoint that week.
Right.
If necessary.
Will do, Judge.
You're welcome. Ms. Jackson. Ms. Jackson here?
Yes. Yes, I'm in
All
here.
right. Did you hear everything?
Yes, I got everything. Thank you.
Okay. All right. Good luck, everybody. Thank you for showing up.
Thank you, Judge.
Thank you, Your Honor.
Helpful. You are welcome. You all have a great day.
You do the same.
You as well.
Thank you.
You're welcome. All right, we've got the Katrina Mays cases. The Sharif Walker case that needs a little research. Sean Thomas, who is missing in action. And Brittany Williams and James Chalmers. And then All right, so I see hands up. Attorney Flussman.
Yes, Your Honor, I've got some answers on Mr. Walker's case here.
All right, let's recall it, see if we can get closer to the solution. Recalling case number 23345-327-3220 Carlin LP versus Sharif Walker.
Yes, Your Honor, Dennis Flesland, P 30289 on behalf of the plaintiff. Your Honor, as I think Mr. Walker is still here as well. Your Honor, as I indicated, our client purchased this property at 15747 North Lawn in Detroit from the Wayne County Treasurer on August 31st, 2018. Mr. Walker has presented a deed that he claims transfers the property to him that is dated June 19th of June 7th of 2019. Your Honor, as a result of that, those documents, the plaintiff in this matter, Carlin LP, filed an action to quiet title in the Wayne County Circuit Court in 2020. That case number is 20-014436CH. In that matter, a default judgment quieting title was entered against Mr. Walker as a defendant and a person named Robert LeBlanc and Demond LeBlanc as well by Judge Kinney of the Wayne County Circuit Court. Mr. Walker hired an attorney, O'Day Meroway, who filed a motion to set aside the judgment in that case. And that judgment, or his motion trying to set aside the judgment, was denied by Judge Kinney on October 21st, 2022. Mr. Walker also, through Attorney Meroway again, filed an action in the Wayne County Circuit Court in March of 2022. That would be case number 22-003729CH, which was, I don't know what kind of complaint that was, but it was dismissed for non-service by Judge Kinney on August 2nd of 2022. So, Your Honor, based upon the nature of the deed presented, as well as Judge Kinney's judgment quieting title in the plaintiff, as well as his decision denying the defendant's motion to set aside that judgment, Your Honor, I think it's a closed deal at this point that 3220 Carlin LP is the rightful owner of this property and is entitled to possession.
All right, Mr. Walker.
That's not true, sir, because Judge Bruce, he dismissed the last case, and you cannot register a house under appeal box. And that's not true. The whole time I've been working on my house, I never got approved of service. So whoever this company is, which is his name, Christopher Brown, his name popped up, then they went back into appeal box. That's why they denied it, because he keeps switching his name over. The house is registered to me. You can't understand, but the house is registered to me, Judge. Right now, I am in the payment plan to paying my taxes again. I done paid taxes on this house 4 years. This is denied. So of course I can't talk, but I'm trying to tell you.
It sounds like, Mr. Walker, you're paying somebody else's taxes. Has your client been getting the benefit of taxes paid, Mr. Flesland?
I don't know what the status of the taxes are, Your Honor. If that's
all
true,
up to date. That's all.
Your Honor, if that is true, there are procedures in the quiet title action to recoup any of those funds. I mean, there are a lot of complicated rules about that, but there are ways to do that. But
right,
it's not in this case.
What's the point of even mentioning it? You know, that rule, those complicated rules aren't going to come about. I'm just trying to figure out if this guy's been paying property taxes for 2 or 3 years and you
I
all.
have, so can I file a motion of get my money back? I'm trying to just take my money.
You're gonna have to have an attorney, but let me talk. You keep cutting him off. You keep getting angrier and angrier, Mr. Fleston. I'm not saying you're wrong. You're right. All I have to do is look at the complaint and the quiet title that I need a copy of. That's what I'm gonna ask for. I'm gonna ask for you all to forward over whatever documentation you have. We come back next week. I'm gonna look at this quiet title. If that quiet title is exactly what you say it is, Attorney Fleston, boom. And in the meantime, I want to just see if he has been paying 3 years of taxes, just so you all can have a meeting in the minds before you never see each other again. And that's totally unrelated to this, but I'm curious to know if taxes were being paid. Doesn't have.
It was, sir.
That's just something that I would like to know because.
It would have been a loss to the house, dude. Oh my God.
Because Mr. Walker is most likely, if we don't arm Mr. Walker with all the information, it's no telling, he's not convinced. He's not gonna be convinced by what you tell him. And I have to make sure I have all the documentation so Mr. Walker knows the exact situation. If it is what I think it is, Mr. Fleshland, your client probably does own the house. But I'm not going to rule today, leave Mr. Walker angry and confused. I can't control someone's emotion, but we have to make sure that both parties are informed moving forward, or your client might not even have a house. That's the practical aspect of this. So let's set this off until, I don't know, it's your pleasure, whatever day you want to come back, Attorney Flesland. All I need is the quiet title document. If I have the case numbers, I can look them up, but if you can give me something that just shows, the default was granted, or okay, first case, default was granted, motion to set aside, judgment was denied. So I'll take a look in the ROA, but I'd rather, if you have anything, give it to me. But
Your Honor,
go ahead.
I'm sorry, do you want us to fax them to the court or email them to you directly, or how do you want us to do that?
You can email it to me directly.
I can email my taxes that I pay my taxes right to you too, sir.
Okay, and Mr. Walker, I also want to let you know, paying taxes is not indicative of ownership. I can pay your taxes today. I can pay somebody else's taxes. So that wouldn't prove that you own something, but that'll keep you from losing whatever you did own. So just keep that.
How do Wayne County let you register a deed if it's supposed to be their house? And why I was working on the house and he never came and said, stop working on the house, sir?
We're gonna sort all this out. And before you come back to court.
Still houses, 32 Carlin still houses.
Mr. Walker, be quiet, man. Be quiet. I'm trying to spoon feed this information to you. It's your duty to figure this out. I could enter a judgment today and just enter a judgment and you don't know what's going on. But I see that you don't understand the full picture, and I'm gonna make sure that you do. But don't yell at the court in the meantime, okay? I'm impartial. I have 50 of these a day, every day. So we can do this every single day with 50 new people. I wanna make sure you are aware of what's going on. That's why I told you that. And Mr. Fleston is gonna give me the information, because I don't want this to be you leaving this house with 3 years of taxes that you paid, thinking things are a conspiracy theory or something's wrong. Maybe you went about it wrong, maybe you didn't, but we're gonna get clarity before we enter a judgment. And that's all I can do. That's all I can guarantee you. So, Mr. Flesland, when would you like to come back? It can be as brief as you want.
Your Honor, I've got the documents right in my hand right here that you asked for. I can come back next week, give you a chance to look at it, if that's adequate.
Yeah, that's adequate. That's adequate. June, Mr. Walker, June 30th, June 31st. What do you think?
June?
Or May 30th, I'm sorry. May 30th, May 31st, I'm sorry. All right, I'll see you all back May 31st at 10 a.m. And Mr. Walker, whatever, I'm going to, let me just tell you my email right now. I'll put it in the chat.
Okay.
Okay.
I'll put it in the chat, and that way you all both have it. If you want to send me something, just send it to the other side as well. I just want to make sure I'm giving you the right email. So, 1 second. Because there's one thing to issue a result, it's another thing to understand it. And parties are walking away with a clear understanding. And that's what I'm going to make sure happens in this case. Because you're not convinced, Mr. Walker. I can see it on your face. You're not convinced. And whether it's in your favor or not, we're going to make sure parties understand. Okay. So that's my email. It's in the chat, Mr. Walker. So either side, you all can send me stuff. I would exchange emails to each other if you need to, but good luck in the meantime, and I'll see you all back on the 31st. All right?
Thank you, Judge.
You're welcome.
Thank you, Judge.
You're welcome. Yeah, I'll see you all back. Just take a breather, Mr. Walker. Take a breather and get your ducks in a row, and we'll be back, all right? Okay. Mr. Hart.
Judge, I got one ready with Attorney Barishai ending in 483. It was before you at 9 a.m.
Calling case number 233458483, number 2 Properties Co. versus James Chalmers in all occupants.
Good afternoon, Joe Horka, P75969, appearing for the plaintiff.
And good afternoon, Your Honor. Tom Barishai, P83642, on behalf of defendant James Chalmers. James, could you state your name for the record?
James Chalmers.
Thank you, Mr. Chalmers. All right. Where are we on this?
Your Honor, sorry to interrupt there, Your Honor. We're scheduled for a trial today, Your Honor, but we've agreed to a conditional dismissal. I can put the terms on record.
All right. I'm ready.
The amount due and owing is $4,965. The defendant shall pay a regular rent by the 1st of each month. Defendant shall also pay $600 towards the arrears by the 15th of each month. Box 4B will be checked and box 7 will be checked, Your Honor. And the last condition is that if the tenant shows proof of payment of a water bill or security deposit, which are elements of the ledger, the plaintiff shall credit the defendant for having paid that.
Okay. So whatever's in the name. All right, but $4,965 shall be paid in the following installments. $600 by 15th of the month.
Yes, Your Honor.
And rent must be paid simultaneously. So Rent is paid when it's due at the rate of $900 a month. And additionally, $600 are to be paid. So the $900 doesn't factor into the 4965 except for May's delinquent payment.
That's right.
Okay, well, lack of payment, but, okay, so $600, where you at, Mr. Chalmers? You got?
Yes, sir.
4965 only applies to what wasn't paid. So you're gonna chip away with that $600 a month or more, depending on how you pay it. But 900 for sure has to be paid by the 1st or whenever it's due. So you have until the 15th to pay that 600 each month, but non-payment of each will breach this agreement. And once you breach the agreement, you can get a judgment or a writ issued in your name. If you follow the agreement, case is dismissed. So, are all parties on the same page?
Yes, Your Honor.
All right, and Mr. Chalmers, do you give Mr. Berishai, your attorney, permission to sign your name?
Yes.
All right, court is satisfied. We'll enter this conditional dismissal upon receipt. Thank you for working it out, parties. And good luck, Mr. Chalmers.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
Oh. Mr. Hart, do you have anything else?
I think I have a couple defaults, Your Honor, ending in 464.
464, calling case number 2334646, City Living LLC versus Davina Hayes and all occupants.
Morning, Joe Horka, P75969, appearing for the plaintiff.
All right. Ms. Hayes, are you here? Davina Hayes on Prevost 8937 Prevost. Counsel, I don't think anyone is here from 8937 Prevost, so you are welcome to request what you need from the court at this time.
Judge, it's a termination tenancy case. I would seek a default judgment of possession.
This is a termination case. Defendant failed to appear. Default judgment is granted. Defendants must vacate by May 25th, 2023, or a writ of eviction may issue. That is case number ending in 46464. Default judgment.
So my last matter was E&E versus Sean Thomas. 274.
Calling case number 23345-274. This is E&E Capital Management versus Sean Thomas and all occupants.
Good afternoon, Joe Horka, P75969, on behalf of the plaintiff.
All right, thank you. Sean Thomas. Sean Thomas. All right, is Mr. Santiago here?
Your Honor, Mr. Santiago is actually in 36th District Court in the building, but I believe this was just a counsel and advise case. I don't know that he filed, did he file an appearance?
I mean, it looks like an appearance was filed, but I mean, the defendant isn't here.
I did reach out to Mr. Santiago and he did not believe he was representing him.
All right, well, I'll default the case, and in the event there's some representation, we figure it out at that point. Is there a Sean? Thank you, Attorney Luan. Does anyone live at 15031 Hayden Street? Council.
Enter to subsequent hearing for non-payment of rent. The delinquent balance, including court costs, is $3,065. I would ask for a default judgment of that amount.
All right, this matter was adjourned was adjourned to the 15th, which is today. Default judgment is granted because defendant failed to appear. It's unclear. Yeah, defendant failed to appear. Default judgment is granted. $3,065, that's 3065, must be paid by May 25th, or a writ of eviction may issue. All right, so you are welcome. Thank you, Attorney Horton. All right, we have 3 cases. These cases, we have to take a lunch. We have a union break, and that's required for the court reporter and my clerk. And we've worked all the way up to 12:30. We have a 1:30 docket. So Katrina Mays, this is 575, 576. And then the one case with Kimberly Black and Brittany Williams. Those will all be called at 1:30. Sorry to inconvenience your morning if it was an inconvenience, but it's no getting around. I can't skip this hour break. So if anything, you all use it as an hour break, use it as a negotiation. And Mr. Walker, I can't speak to you without speaking to both parties. I have to be a neutral party. I know we don't know each other, and whether I know you or the other side, everything's got to be shared where both sides are aware of the messages. So ex parte conversations, I can't have them with you. I can't meet you at lunch right now and tell you what you need to do to prepare for the case. I can't have side conversations. The attorney in me wants to fix this, but I can't. And I don't know if it will be in your favor or not anyway, but I can't have a side conversation. So the best thing you could do is try to get an attorney, or just come ready and prepared on the 31st. But I'm not even gonna read what you sent me. I'm just going to ignore this message and consider it water under the bridge. And I'll see you back on the 31st. Take care, Mr. Walker. I'll see you go back after lunch. Or break, or whatever you want to call it. 12:30, 1:30, we'll be back in action, and we'll be ready to hear your 2 cases, Ms. Mays, and also yours, Ms. Jackson. Ms. Black, Kimberly Black. So use this time, use this hour, use this hour, take a break, but we have to take a break or we're gonna run out of steam anyway, so.
Your Honor, before you kick us off, what was the Black case number?
Kimberly Black's case number is 2334-6271.
Thank you.
You're welcome. All right. Let's make good use of this time, and I'll see you all back in an hour.
So we come back at 1:30?
Yeah, 1:30. Curtis Thompson, are you still have a case? Are you still, you're on that? Yeah. 1:30.
Okay, thank you.
1:30, 1:35, but if you leave, I can't let you back in to the Zoom room. So without.
So don't leave the Zoom.
Hold on, is somebody gonna be here from UCHC who has co-hosting powers?
Yes.
Yes, Your Honor.
Like, are you all able to admit somebody with co-hosting into the Zoom room?
Yes, we are.
Okay. All right, perfect. Well, if someone's here and you're in a Zoom room, then chances are you can still get in, but if you leave, it's gonna be hard to get back in.
Okay,
But
so just don't leave, just come back.
yeah, just you can leave and come back at 1:30.
Okay.
Turn in the meantime or something, but we're done until 1:30.
All
Probably
right.
1:30.
Thank you.
You're welcome.
Yeah,
Hello, everyone. This is Judge Sabree's clerk. Court will resume shortly. Sorry about the delay.
Thanks. And Curtis, if you could give privileges to myself and our legal assistant, Christina, and I believe Kenitha as well, that would be fantastic.
Sure, no problem.
Thank you so much.
You're welcome.
Hello?
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 Hi. Good afternoon.
Hello?
Good afternoon, everyone. What's your name for court, Zoom user? Hello, can you hear me? Yes, I can hear you.
Oh.
The person on the person on phone.
Hello?
Hello, what's your name, ma'am?
My name is Elaine Glenn.
Good afternoon.
Elaine Glenn.
Okay, you can place your device on mute.
Quentin Brown.
Hello, can you hear me? Yes, I can.
How many
Hear you.
different calls?
The person on phone. Hello?
Hello, can you hear me? Hello?
What's wrong with the Zoom?
Yeah. Can you hear me?
Hello?
Hello. Hi.
Listen, everybody stop talking, please. Good afternoon. I'm Judge Sabree. This is Landlord Tenant Court. This is the afternoon docket. If you're calling in on a cell phone, or if you're calling in on a phone, please wait. If you're muted, stay muted. There's one person, we're gonna go one after a time because you all don't know who you're talking to. Good afternoon. So all just keep talking to each other. So Zoom user, who is this who's calling in on the phone? No, this is not even a phone call. It just says Zoom user and it's an echo. You're unmuted. What's your name?
My name's Tyrone Paris.
Tyrone Paris?
Yes, sir.
Yeah. All right. We have you checked in. Person listed as Zoom user.
Go. Why you sound so low?
All right. We're just gonna call some cases. Our parties. We'll be back in person.
Maybe June. Would you shut up?
Hey, be kind. Aylin Glenn. Is Aylin Glenn here? All right. Is Charnel Edwards here? One good thing is that 1:30 is the only time. So everybody's in here. I'll give you one spiel. We'll explain it once, and parties can start talking to attorneys and getting these cases resolved. I'm gonna call out the rest of these names. If you don't hear your name after I'm done calling these names, then we'll figure out where you're supposed to be. There are 4 or 5 cases from this morning that we still need to address, but I've got 10 names to call out. Everybody be patient. Aylin Woods, Aylin Glenn, Charnel Edwards.
Here. Can you hear me?
Yes, I can. Now, Ms. Edwards, good afternoon.
Good afternoon, Your Honor.
Do you have an attorney?
I believe I do. I'm not sure.
Okay. You're with Attorney Smith. Justin Smith is the attorney for the landlord. I'm not. You have an attorney?
I don't see my face. Like,
Are they talking?
yeah, but
Please be quiet. Charnel Edwards.
Yes.
Would you like to speak to Attorney Smith in the event that you think you need counsel, or if you tell him, hey, I want to speak to an attorney, he will invite you to speak to an attorney. If you all can get it done,
Yes.
Call your case.
Yes, please.
Okay, so Attorney Smith, let's make sure you have breakout privileges because I don't want you to get caught in the breakout room. So I just gave you those. And Ms. Edwards, you'll be in the breakout room number 8.
Okay. Do I join now?
Yeah, you can join now. And I'll put you at 8. So Sophia Broughton. Ms. Broughton. Taraya Appling. Taraya Appling. Tyrone Paris. Oh yeah, I see you, Mr. Paris. Are you muted? That unmute for us.
Here I am.
Good afternoon. All right, Mr. Paris, do you have an attorney?
No, sir.
Would you like to speak to an attorney or speak directly to the plaintiff's attorney?
I'd like to speak to an attorney.
Okay. Michigan Legal Services is here. I'm going to invite you to the UCHC lobby. That's United Community Housing Coalition, Michigan Legal Services. They both provide free attorneys unless you don't qualify. So I'll invite you, let them do the intake and let them take it from there. Let me know when your case is ready.
Yes, sir.
Your Honor?
Breakout privileges?
Yeah, I need breakout privileges. And so does Christine. Thank you.
Christina has it, looks like. Right. Calvin Scarver. Ashley Flood or Raquel Flood. Ashley Flood. Nope. I'll take this. Alicia Anderson, Frederick Hill. And I see Sylvester Brown is here. Good morning, good afternoon. And where is Quentin Brown? I see Quentin Brown here as well.
Darlicia Anderson is here.
Okay. Quentin Brown is here, Alicia Anderson is here. All right. If you're are you requesting an attorney? Ms.
Yes.
Anderson?
Yes.
Okay. I'm gonna invite you into the UCAC lobby.
Thank you.
You're welcome. All right. Let's see. All right. All right. Party's ready on Edwards.
Yes, Judge, we are.
Calling case number 2334-6486. This is Zest PM ACCG 401K Trust versus Charnel Edwards and all occupants.
Your Honor, Justin Smith for the plaintiff in this case. My P number is 51886. And with us now, I think in the gallery is Ms. Edwards.
Yes, I'm here.
Good afternoon, Ms. Edwards.
Good afternoon, Judge Sabree.
Your Honor, we've worked something out that will be a all occupants judgment for a 1 month move for the 15th of June for a move date. I've explained the court rule regarding the fact that she doesn't have an attorney and she has 3 days to ask the court to set this aside.
All right. So parties agreed that the named party will be removed. This is a termination of tenancy case. So there's no amount monetarily to redeem. However, you've agreed that all occupants must vacate the property by June 15th. Is that
That is correct.
June 15th, 2023, or a writ could issue thereafter. So the judgment won't be in your name, the eviction won't be in your name, and eviction won't occur if all occupants vacate by June 15th. And if you don't, or if someone else is there, then he has every right to file an eviction. Any questions, Ms. Edwards?
No, not at this time, sir.
Okay, all right, well, thank you for your patience and have a great day.
You too. Thank you so much. You too, Mr. Smith.
My pleasure.
Okay, let's see. And Tyrone Paris checked in with legal counsel on 490.
Okay.
Smith.
I'll mark that.
And you don't have to, everybody, no one else responded, so.
My batting average is low today, Judge.
I'm able to leave, correct?
Yes.
You are. Thank you, Ms. Evans.
Thank you.
Okay, Judge, I guess we'll check back on the others.
Okay. All right. Okay, recalling case. Is Attorney Bonds here?
She may be in a breakout room, Your Honor.
Okay, yeah, looks like she's with Ms. Williams. Let's see.
I'm still here.
All right. Once Brittany Williams and Kiana Bonds are done, I can call your case since they're the defendants and the attorney on the other side. And let's see, looks like Attorney Bonds is out.
I was in the breakout room.
Yeah, I saw you in the room too. Are you ready on 271?
Oh, good Lord. You didn't.
That's Brittany Williams.
That's who I was just speaking with. Yes, I just asked her to come out.
Okay.
All right. This is Attorney Kiana Bonds, P number 78423 on behalf of defendant.
I didn't call it yet.
Oh.
Let's see. Calling case number 2334-6271. This is Kimberly Black. Williams. Can you state your name? Ms. Bonds, can you state your name one more time?
Of course. I'm sorry, I didn't know if you wanted Plain to go first.
Yeah, info part planner, so I'll take them as they come.
All right. Attorney Keon Bonsby, number 78423, on behalf of Ms. Brittany Williams, who is present with us today.
All right, Ms. Williams, can you state your name?
Hi, Brittany Williams.
All right, and Ms. Black. Can you state your
Kimberly
name?
Black, present.
Thank you. Were parties able to work out a resolution, or were they able to get some clarity on what's going on?
Okay. From my understanding, I was able to pull out the title, but from speaking with my client and her mother, they believe that there was fraud. There was fraud in getting the title, and we're asking for 30 days to clear the title and file a claim in 36th District to get the clear title.
Oh, then Third Circuit file a claim in Third Circuit to get to quiet the title or clear the title?
Yes.
Okay.
Your Honor, may I speak, please?
Absolutely.
I don't know what fraudulent stuff is going on, but this is definitely misleading you. My mother is the one that initiated putting the quitclaim, initiate the quitclaim deed. And I have 3 people who can attest to that, including the person who generated the quitclaim deed on my mom's behalf to me. I did not contact my mother to ask her to put the house in my name. She put it in my name because she said I'm the only one that she could rely on as far as taking care of the property. So I'm willing to take a lie detector test. I think she should take a lie detector test, and that'll clear up everything. So I have no reason to lie today.
Ms. Oliver is also present. She's with Ms. White.
Miss Oliver is deceased.
I mean, not Ms. Oliver, that's Ms. Williams. I apologize.
Yes, is here with me. Like I stated in the last session, my mom and even Miss Black had came and said that my mom had put her on both houses for the will.
I never stated a will.
Yes,
I never once stated the will.
Excuse me, I did not cut you off when you were speaking. Thank you. So do not cut me off. Thank you very much. She stated that she would get both houses if something happened to my mother, and that she would see if I wanted to get my mom's house if she did pass before she think about selling it or whatever.
One
like
moment.
I stated last time when she came over here in February, and she stated that my mom wanted me to move. Never stated that she was owner, nothing. My mama still as landlord. November, December, and January's rent was paid to Betty Williams. When it came to what little money did get paid on the taxes, because that's what she was supposed to be helping my mama pay the taxes off, because my mom thought the house was going into foreclosure and she was going to lose the house. The little money that did get paid, Betty Williams paid it. She has not paid any. She did not pay. My mama paid it herself, because my mom stated that she told her that since she's the owner of the home, that she had to make the initial payment, which was $600 and something.
One moment before you continue on. Judge Sabree, this is a mother and 2 sisters. The mother, Ms. Williams, is there who can attest to any questions you have if you want to swear her in.
Okay, and where is the mother? Okay, she's in. All right, ma'am, can you state your name?
Betty Williams.
And do you swear to tell the truth and nothing but the truth?
I swear.
All right. Okay, so let's backpedal. Is Miss Williams, were you previously the owner of 18472 Eileen Street?
Yes, because my mother passed and the house became mine.
Okay, and did you at any point transfer the property to Miss Kimberly Black?
not the way it's done now. No, I wanted to put her on there in case if something happened to me, the house would become hers. That's the way it should have been and was supposed to be. My name was not supposed to be taken off at all. That's the way I wanted it.
And who drafted the deed?
He said who drafted the deed?
Oh, the papers?
Yeah.
Marcia Guy.
And where's Miss Guy?
Well, I can't reach her because she was out of town and she said she would be back by the weekend, and I'm still trying to get her.
Okay, now, okay, so did you, Ms. Williams, did you transfer the property to Ms. Black?
No, I signed for her to be like on the wheel if something happened. That's what I thought. I didn't know.
Okay.
And then when I found out later, I was so upset because that's not the way. I never wanted to get rid of my mother's property.
All right. So how did it come about that Ms. Black is filing an eviction?
What?
He said, how did it come about that Ms. Black is filing an eviction?
Well, when my daughter came to me and said, you gave your house away to Kimberly.
Well, she's saying, how did it come about that for the eviction?
What, for you?
Yeah.
She wanted me to come and tell her that she had to move out and she could move, and she wanted to get some work done and she would move back in. I said, no, I don't want to do that. But see, I didn't know. I wasn't gonna be doing all that running around, and I told her to do it because I was putting her name down. Just,
Okay, all right.
But it wasn't supposed to be.
Fine, if you have questions, and I'm gonna unmute Ms. Black and allow her to respond unless you have some questions, Ms. Williams. Attorney Bonds?
Not currently, Your Honor.
Okay. All right, Ms. Black, I see you have your hand up. Let's see if we can get this seems like.
Your Honor.
Yes.
So first and foremost, that is totally false. The person, Marcia Guy, who performed the quitclaim deed, she can attest to the fact of what was conveyed to her is the same thing that was conveyed to me. All of this initiated in October, like the end of October. My mother called me while I was at work, and what she asked me was if I was willing to buy my grandmother's house. And I said, why would I buy something that grandma wanted me to have? So then she proceeded to tell me that the house was in foreclosure. The first question that I asked her was, quote unquote, since Brittany is staying there, have you asked her to help you pay the past due taxes on the house? Her statement was to me is, Brittany pieces me my money every month. I can't even get her to pay the full $625 at one time. She pieces me the money. And then she also stated that a while back, Brittany had offered to pay her $10,000 to buy the house. And she said, would I look like selling her my mother's house for $10,000 when she can't even pay me the $625 a month for rent? So then at that time, I told her, I said, well, since you're behind in the taxes and the house is about to go into foreclosure, I said, the only way that I'll get involved is if the house is in my name and I pay the tax and the house is mine. At that point, she stated, I have no problem with that because you're the only one I could depend on and you're the only one that's reliable. In November, it was in November was when we went over to Marcia's home. Marcia explained to her the paperwork saying what you are saying is you're giving, you're putting Aunt Reese's house, her name is Marie Oliver, you're putting Marie Oliver's name, house into taking it out of your name and putting it into Kimberly Diane Black's name. Marcia explained all the paperwork to her at the time, went over all the verbiage and everything. My mom says yes. And at that time, she blindsided me, telling me that she wanted my name on her house under survivorship should something happen to her. And then to move forward, at that time, I went and registered, we went and had the, I met her and a guy named Lonnie Jones up at Comerica Bank at 6 Mile and Myers. And before the person, the notary, my mom had to give her photo ID to, prove who she was. And the notary asked her, you're wanting this paper notarized. And my mom says, yes, I'm putting this into my daughter's name. And at that time, the person who notarized the paperwork notarized it, gave me the copies that said that, that's when I go downtown. On November 23rd, 2022 was when I went downtown to file the paperwork and pay the $15.77. Once I came back, because that was the day before Thanksgiving, I called my mom, told her I was back. And what she said to me is she said, I need you to talk to Brittany because I want her out of the house. And so at that time, I said, well, what time frame are you looking at? She wanted her out at the end of December. And I said, well, that's not fair. You should at least give her, until the end of March. She called me back the next day with Lonnie Jones on the phone because they were on his phone and had me on the speaker phone and said she wanted her out at the end of December. And again, I stated, no, it's not fair. If you're going to put her out, you should ask her to move out at the end of March because that allows her time to find a place. Lonnie Jones chimed in and said, well, yeah, she should have money for her income tax by then, so she should be able to find a place. That's reasonable. So that's how everything initiated. I did not initiate anything. I didn't ask for anything to be put into my name. And then on Saturday, December 3rd, I went over to Brittany's house and I had a conversation with her because my mom said that it would best, Brittany would receive it better if it came from me as far as her wanting her out of the house versus it coming from my mom. Lonnie Jones was a witness at that time on the speakerphone. And I said, Mom, it would best come from you because you are the person she been paying money, to stay there. I said, you need to convey that to her. She said she didn't want to go over and talk to Brittany because every time she's had conversations with Brittany, Brittany jumps all up in her face and gets aggressive and she was tired of arguing about the matter. So that's when I went over, had to talk with Brittany. And then my mom denied that. She said she wanted Brittany out. And then Brittany said she needed more time. So then all three of us, I had my mom on speakerphone to verify that my mom did indeed say she wanted Brittany to move. And we agreed upon May 31st. On February 6th, my mom called me to inform me that Brittany did not pay her rent and told her she wasn't paying her rent since she was moving. She had found a place. And then that's what happened on February 21st at 6:38 p.m. on a Tuesday. My mom and I went next door because my mom lives next door to the premises and informed Brittany that she had to move. That's when Brittany got very egregious and started getting loud and said, I'm not moving. And if I do move, I'm not moving out to May 31st, which was the original agreed upon date. My mom wanted her out February 28th. And I told her, Brittany, what my mom had said. But again, I got caught in the middle and now I'm being painted like I'm like I done stole some property or tricked her. Marcia Guy is the one that drew up the papers and she can clearly state exactly the how everything happened in chronological order.
All right, was there anything written? Was there any contract? Was there any type of email or communication, something that somebody can show, prove? Because I'm not, if this is a title issue, I mean, I could hold this. I can hold this in abeyance until that's cleared up. I can dismiss it and you refile it once it's clear. But
the quitclaim deed is indeed in my name. And I do have the paperwork and I have the, someone even looked it up for me and they found it with the library number and the page number that I provided last week.
I looked it up, yeah. But I just want to verify because people are saying that it's fraudulent. And I
say take lie detector test.
Lie detector test won't do anything and it's not admissible as evidence in the state of Michigan. So you can take a lie detector test all you want, but it's not going to do anything as it relates to figuring out who has the proper title to the house. Now, it sounds like you have the proper title to the house, but it's being contested. So until somebody, was there a deed committed at some point? Did you ever submit a deed with the property, Ms. Black?
Yes, I did. I gave it to Ms. Bonds as far as for her to look up the information, and I provided you with the same number as well last week. And I put the information up to the screen because you wanted to see it, or I believe she wanted to see it as well. And for the record, I have been paying the taxes on the house, and I have bank records showing that because I paid by my debit card.
And more so, who has? All right, Ms. Bonds. You explaining fraud.
Just wait.
Is there any particular? Is it anything that you can present to the court to demonstrate that Ms. Black operated fraudulently?
I literally got half of that.
I did receive testimony from Ms. Williams stating that it wasn't her intention to deed the property over, but also she also mentioned that she deeded the property over. So
I signed it, but I thought I was signing.
Do you have anything else to present to the court, Ms. Bonds, or anything that could identify what you're alleging?
Ms. Black has stated that there could be somebody else who could go in forth on what was described. From what Ms. Williams has stated, Ms. Betty Williams has stated, she has stage 4 glaucoma and is not able to see well, severe glaucoma. So she was saying that the paper being presented to her was not what she was told. At that point, we're still asking, can we have the person who drew up the paperwork to attest to that, or if we can have the title cleared in Third Circuit? Because she's not able to read it. If she's not able to read the documents, it doesn't make sense.
Your Honor, she was thoroughly explained. I'm sorry. It was thoroughly explained to her at the time because I was there. My son was there. Marcia Guy was there, and Marcia's daughter was there as well.
Her son was not there.
Marcel was there. He rode with us.
Not there.
She said, I thought she said.
All right.
No, he wasn't there. He didn't go there.
Marcia Guy. When can Marcia Guy and Lonnie Jones appear on Zoom?
Lonnie could appear now.
He's been drinking now.
I want to hear their testimony before I file this. Before I enter a judgment.
If I could just say one more thing, Your Honor, this is not the first time that Kimberly Black has sat here and did.
No, can't say anything. Can't say anything. Ms. Black can't say anything. What's the best date, Ms. Bonds, for us to come back? Where Ms. Guy and Mr. Jones. I would have let you say something, but every time I open up the floodgates, it just turns into an argument. And you all can argue outside of court. I don't need you all to sit in my courtroom and argue. So there's an attorney. She can speak for you right now. And I don't want to displace anybody if there are allegations of fraud. Now, fraud needs to be played with particularity. And it's nothing really, I did hear some testimony, but I'll allow both sides. Ms. Black, you're saying that Lonnie Jones or Marcia Guy knows what's going on. So how much time, Attorney Bonds, do you think you need to get the other witness in? And Ms. Black, you can unmute to tell me whatever you need to tell me related to Lonnie Jones or Marcia Guy.
I'd ask that we have 2 weeks. I know that 29th is Memorial Day, so the 31st or the 1st.
We can do May 31st.
Your Honor?
Yeah, yes.
Oh, yes. So Marcia Guy said that she is willing to appear on the Zoom meeting.
Okay, May 31st, is that at 9?
They're saying they want to know if May 31st will work for you.
Yes.
Yes.
Absolutely.
Your Honor, she just wants to know, do you have a time as to when she would need to appear?
9:30.
9:30, he's saying on May 31st at 9:30, yes. Yes, she says she will be able to appear at 9:30 on May 31st as the date that you have set forth.
Okay, all right, thank you.
Thank you, sir.
You're welcome. And Attorney Bonds, I'll see you back May 31st with Ms. Williams.
Yes, sir.
All right, and whoever wants Lonnie Jones, make sure you get in touch with them, and I'll see you all back.
Thank you, Your Honor.
You're welcome. Attorney Smith, then Attorney Goodwin.
Your Honor, I had just have a dismissal to put on the record. That's why I raised my hand if you want to take care of that one. It would be 491.
Calling case number 23346-491, Michigan Real Property versus Calvin Scarver and all occupants.
Your Honor, Justin Smith for the plaintiff, P51886. We had sent in a dismissal form on this case. I believe that my client does have keys.
Okay, so this matter is dismissed without prejudice. Thank you for putting it on the record.
Thank you.
We'll enter it and sign that dismissal if we haven't already. All right, and Miss Athling. I saw Miss Athling pop up. Did you have an opportunity to talk to her?
Yes, I'm here. I haven't been able to talk to anyone. It's Taria Walker.
Oh, Taria Walker?
Yes, Your Honor. I was saying that I haven't had an opportunity to talk to my attorney or anything. I was just answering your question.
Oh, okay. All right.
Mm-hmm.
Do you know who your attorney is?
Honestly, Your Honor, I don't. I remember my last court date, which was with Judge Bree. And then I had got into the breakout room to talk to someone from legal aid, but no one has gotten in contact with me after that. I didn't even get a chance to talk with anyone in legal aid, so I honestly don't know.
That's what I wanted to see. Thanks.
I get it, but you had to just be patient.
Right, so do you want to speak to an attorney?
Before we go further?
Yes.
That's fine. I could speak with one.
No, I mean, if you don't, I can put you in a meeting with Mr. Smith and we can probably call this case in 5 minutes. That's why I'm asking.
I mean, it would be nice if I could just talk to him for a couple of minutes before we get back into the, before we proceed, if that's okay.
You said talk to someone who
You
can
were
represent before.
okay. Do you want me to go ahead and join this breakout room that you put up?
Your Honor, we can have someone from Michigan Legal Services speak with her if she wishes.
Okay, yeah. So join that breakout room, Miss.
Okay.
Ms. Walker.
Okay.
All right. Thank you. All right, party's ready on. Let's see, it's Curtis Thompson here and Mr. Christensen is here. Recalling case number 23346-575. This is Katrina Mays and all occupants.
Audrey Thompson is here, Your Honor.
All right,
Judge, Ms. Mays, she called. She said she was having issues on the Zoom, or she said she was in a waiting room. Is here. Okay.
Your Honor, can you hear me? I'm here.
Okay. Yeah, I can hear you. Good morning. Good afternoon, Ms. Mays.
Good afternoon.
All right, this matter multi-unit. Okay. right, and is Attorney Bonds on this matter?
Yes, that's my attorney, Your Honor.
Okay,
I believe she might have just gone to Kennedy's courtroom. This is Ben Christensen with UCHC, Your Honor.
okay. Well, what we can do, we'll just call your case.
Well, my case is really contingent on matters in Attorney Bonds, but we can try to resolve my case as well.
I mean, I think we should have Attorney Bonds here because we've already tried to do this without.
Yeah.
So we'll
I
wait.
agree.
I mean, I can wait. We just have to wait it out a little bit. That's what happens.
Okay. I'll alert her right now. Thank you, Your Honor.
Yeah, I mean, if she's in the Zoom, then yeah, do the best you can do.
Will do.
All right. Attorney Smith. Oh, Attorney Goodwin. You need some breakout privileges. No? Not privileges. I can't hear you though. Okay.
Sorry, can you hear me now, Your Honor?
Crystal clear.
Thank you. Your Honor, here for the case of Sylvester Brown versus Quentin Brown. I'm actually ready to proceed if we're ready, if the court is ready.
The court is ready. Calling case number 2334-6527. This is Sylvester Brown versus Quentin Brown.
Your Honor, keep the PA 3997 on behalf of Quentin Brown.
Thank you. And is Sylvester Brown here?
Yes, Your Honor.
Can you state your name for the record?
Sylvester Brown.
All right, thank you, Mr. Brown. Mr. Brown, do you live? Mr. Brown, do you, all right, Sylvester, can I call you Sylvester?
Yeah, that's fine, Your Honor.
Okay. Sylvester Brown, do you own the property at 8385 East Lance?
No, Your Honor.
Okay, who owns that property?
My mother. And I'm also her guardian too.
Okay, are you officially her guardian?
Yes, I have the paperwork. I can, I'm not sure how you do this. I can email it to you.
Okay, hold on, let's get through. Let's see if I may need it, I may not need it. But today is the date and time set for complaint to recover possession of property. Did you all Mr. Goodwin, did you have an opportunity to speak to Mr. Sylvester Brown?
I have not yet, Your Honor, though I do want to note some of the history for this case. I've been able to speak with my client. I actually have a copy of the deed for the property. The deed, in our organization, we had a person do a title search for the property, and the deed to the property is, it looks like there are actually more than one Sylvester Browns. There should be a junior and a senior, and I believe the plaintiff's junior. The original deed to the property that's in the register, the latest deed in the property that's in the register in the title records is from 1987, February 5th. This was not just to Sylvester Brown, the original Sylvester Brown, but to Sylvester Brown and Sandra Brown, who is the mother in this case. I believe that the Sylvester Brown, who is plaintiff, who I believe is Sylvester Brown Jr., is brother of Quentin Brown, who's in court. I did find records that there is a guardianship case, but in that case, it does not state whether that Sylvester Brown is a junior or a senior. I also don't know what powers were granted under under the letters of guardianship. So I am still unclear if the plaintiff actually still has authority to bring a case or standing to bring a case. And so that's where the posture is right now, Your Honor.
Do you have a letter of authority, Mr. Brown, from, was it from probate court?
Yes, sir.
All right, is it possible for you to get that to Mr. Goodwin?
Yeah, I can email it.
Okay. Can you do it?
I can do it right now.
Okay.
I can do it right now.
Now, and we'll recall it. And if you have authority, then that's one thing, and then there's one less issue that's on the table. If you don't, but
Your Honor, I do additionally under the court filings too, the papers that were served to Quentin Brown, my client, also didn't have a notice of quit to attach to it. So I don't, I believe there's other issues there as well. I just want to note that for the record as well.
okay. I have one in the file, but duly noted.
Okay. I will chat to the plaintiff my email so you can provide those papers to me.
Okay. And the deed is in your mother's name, Mr. Brown?
Yes, Your Honor.
Is she deceased or incapacitated?
Incapacitated.
Okay. To extent, whatever extent that you need to be the guardian. Okay.
Yes, sir.
Okay. All right. Well, try to get those documents over to Attorney Goodwin, and then I'll recall it. Let's make sure we have authority before we go any further. So, all right. Thank you. Thank you both.
Thank you, Your Honor.
All right, TCL, who is Sylvester Brown? Is this is TCL? Who's on TCL? Is that
TCL? I'm not sure what that is.
Anything? I guess it doesn't have anything to do with you, but it's TCL. I want to know if that person was on this matter. It's a TCL T430W. That's the phone. That's the title that's on here. Can you hear me?
Yes, Your Honor, I hear you.
Your Honor, I believe that's my client, Quentin Brown, on the TCL.
Okay, I thought you all look. I just didn't want to. All right. Yeah, I assume that. Okay. All right. Thank you.
Thank you, Your Honor.
You're welcome. All right, Attorney Devlin, and then Attorney Smith, and then Attorney Fisher, and then Attorney Horton.
Your Honor, I just had a default. I don't know if you're calling those yet.
30, I'm calling. Is Alan Glenn here? ALYNN. Alan Glenn. Calling case number 233464885. This is Millwood Apartments versus Alan Glenn and all other occupants on East Milwaukee.
Your Honor, Adam Devlin, P 72877 for the plaintiff.
Thank you. Is anyone on East Milwaukee in Unit 310?
Gum in my purse. I need something more monster. Please.
All right. Ignore that request. Ignore that. Ignore that. I was trying to get you. All right, counsel.
Your Honor, we asked for a default judgment to enter. It's a termination. I don't know what date the court's using today for its writ date.
Default judgment is granted. Defendant failed to appear.
Yeah, my purse on the door.
Defendant must vacate by May 25th, 2023, or the eviction may issue. Please
Your Honor,
submit it. Go ahead.
Can you confirm that there's a deed in the file, just so I don't have to worry about that?
There is a deed in the file. There's a warranty deed.
All right, sounds good. Thank you, Your Honor.
Who's the D Boys or LLC?
Millwood Apartments is the DBA for the D Boys 4 LLC.
Okay, all right. Create any new issues, Mr. Devlin?
Well, I'd rather create new issues and resolve them on record than resolve them 30 days from now. Have a good day, Your Honor.
Fair enough. Okay, all right, make sure you send that default judgment in, okay?
Yes, Your Honor.
All right, thank you. That was a great response.
It was.
Attorney Smith.
We have a workout, Judge, on 490.
9-0. Calling case number 2334-6490, Invest Motor City LLC versus Tyrone Paris.
Your Honor, for the plaintiff, Justin Smith, P51886.
Dan Stepich Lawan, P48702, Michigan Legal Services, on behalf of the defendant Tyrone Paris, who is with us in the courtroom. Mr. Paris, can you state your name for the record, please?
Tyrone Paris, Jr.
He got to it.
All right, thank you, Mr. Paris. Mr. Tyrone Paris Jr. All right, let's put the terms on the record.
I'll take that, Attorney Luan. And I'm going to read each item on here so that we can fully understand, because you've given me, I think, some authority to sign for you if this sounds right to you. So we're going to be removing in the form of a judgment, which will essentially be a 30-day move, but we're removing the named defendant, which is Tyrone Paris, and it's going to be an all occupants only judgment by consent. The plaintiff on line 1 will have a right to recover possession. I have crossed out the box line 2. I have checked off 4A and 4B, which is applicable to, or 4B rather, which is applicable to a termination case that confers a right to occupy until June 15th, 2023. On line item 5, I checked off the box that says that a defendant may be liable for money after moving if additional rent is owed or if there's damage to the property. I have left number 6 blank. I have checked off number 7, which says no money judgment is entered at this time. I have crossed out the boxes on money judgment. Rather, I have put an X through the amount blanks on money judgment. Further orders, line 10, keys to be returned to management to demonstrate transfer of possession. I have marked 10 days as the appeal date. I have not checked off box MCR 4.201 because I understand Attorney Luan is going to file an appearance in this matter.
That is correct, Your Honor.
All right, so termination in Tennessee with the move out date of June 15th, 2023, where defendant must return keys. Must return the keys to the property management or the landlord. And this is going to be an all occupants judgment. So all occupants judgment with the removal of Tyrone Paris. Did we miss?
I don't think that we missed anything. If it's by consent, just want to affirm for the record that I have attorney's authority to sign.
That's correct. Yes. Sorry.
Okay. Very good.
All right, court is satisfied. Thank you, parties. Thank you, Mr. Paris, Tyrone Paris Jr.
Your Honor, you have a great day, sir.
All right, you too.
Thank you.
Thank you, ma'am.
I'm putting my hand down, Judge. That takes care of that one.
And Mr. Paris, you can sign off.
Roger that, ma'am. Have a great day.
You too.
All right, you too. Is Sophia Broughton here? Sophia Broughton. Does anyone live at 12120 Peyton? Anybody on Peyton in the city? In this courtroom. Calling case number 2334-6487. This is First Rent Corp. Skylar LLC versus Sophia Broughton and all that.
Your Honor, Justin Smith for the plaintiff in this case. My P number is 51886. This is a subsequent hearing termination of tenancy.
All right. It appears that the defendant is not here. Does anyone live at 12120 Peyton Street? All right. Counsel, are you requesting a default judgment?
I am, Judge, for June 15th. Keys to be turned over.
All right. This is a termination. This is a complaint to recover possession. No amount, no monetary amount.
It's gonna be a long line.
Yeah. And defendant must vacate by May 25th, 2023, or a writ of eviction can issue.
Thank you, Your Honor.
You are welcome. All right, Ms. Fisher, Attorney Fisher. Good afternoon.
Good afternoon, Your Honor. We have reached a resolution.
Fantastic. And that's on Darlisha Anderson?
Yes, Your Honor. 6497.
Calling case number 2334-6497. This is 532 Tidal Way LLC versus Darlisha Anderson.
Good afternoon, Joe Horka, P75969. I represent the plaintiff.
Good afternoon, Janetta Fisher with Michigan Legal Services, and I represent Darlisha Anderson. Ms. Anderson, please state your name for the record.
Darlisha Anderson.
Good afternoon, Ms. Darlisha Anderson.
Good afternoon.
Okay. Were parties able to come up with a resolution on this matter?
Yes, Your Honor.
Yes.
Would you like to put the terms on the record, counsel?
I can put it on the record. It's going to be a conditional dismissal. Total amount of money owed or due is $7,214.07, and that does include court costs.
Okay.
So she needs to pay that, and it's going to be 4B with the provision that MLS will be notified if a submission of eviction is requested. And she
like a courtesy email.
I'm sorry.
MLS, as in a courtesy
Michigan
email?
Legal Service.
Okay.
Yeah, Michigan Legal Services. Yes.
Got it.
And the due date for the money is June the 16th, 2023, no later than that, or she has to vacate.
Okay, so Ms. Hill, let's see. Oh, Miss Anderson, I'm sorry. Miss Anderson.
Yeah.
You're going to pay $7,214.04 or vacate by June 16th, 2023. If you do either of those two things, this case will be dismissed. If you fail to vacate or make that payment, 4B is checked on your agreement, which means that a judgment and a writ of eviction can enter at the same time without coming back to court. So either way, this could possibly be our last time in court. I want you to understand that. Do you understand that?
Yes.
Okay.
Your Honor, is 7 cents. 07.
Okay.
Okay.
724.07.
Yes. 7214.07.
Okay. Thank you. And do you, Ms. Anderson, give your attorney consent? Do you give her permission to sign your name?
Yes.
All right. Court is satisfied. Did we miss anything?
No, Your
How do I
Honor.
receive that document?
Ms. Fisher, can you email it to Ms. Anderson? Or however you all can transfer documents, but you do have counsel, and I think Ms. Fisher can get it to you, absolutely.
Okay, great, thanks.
Yes, I can do that, Your Honor.
Okay, however you all need to do it, just feel free to coordinate. But you'll receive something in the mail, but our paperwork is moving a little slow. So it's in the
Right.
system. Your marching orders 7214.07 by June 16th.
Okay,
All right, good luck, Ms. Anderson.
thanks.
You're welcome. All right. Thank you, Attorney Fisher.
Thank you.
Hanging out, Attorney Smith.
Yeah, I see a couple here that haven't, I don't think that there's been a check-in from a defendant yet, 494 and 492.
How do I get back to the lady?
Let's see. What'd you say, Ms. Anderson?
I'm sorry. How do I get back to the lady?
I can put you all, I'll invite you into a breakout room. So you all can kind of recap. So let's go back. I'll move you to room 10, just so you get another invite. Here you go, it should pop up on the screen. And let's see. Is it Raquel or Ashley Flood? Who lives on Barlow Street? Does anyone live on the 19,000 block of Barlow? 19,000 block of Barlow. Calling case number 2334-6492. This is Domus PM S8 Investment LLC versus Raquel Ashley Flood and occupants on Barlow. May I have appearances, please?
Your Honor, Justin Smith for the plaintiff, P51886, subsequent hearing on a termination tenancy case at the subject address you've cited.
All right, thank you for your appearance, counsel. One final call. Raquel Ashley Flood or any occupant that lives in 19405 Barlow. Any takers? All right. Counsel, it doesn't appear that the defendants are present today.
Accordingly, I would propose that I would send in a proposed judgment for default with a move date of May 25th. The keys to be turned over at that time.
All right. This is a complaint to recover possession of property, which means that there is no monetary amount to redeem this property absent a side agreement, written side agreement. But in this matter, it's a termination of tenancy case where all parties must vacate by May 25th, 2020, or a writ can issue. So default judgment is granted. There's only so many ways you can say this.
Nope, that was pretty good, Judge.
All right, are you ready for, does anyone reside at 19836 Moros Road? All right. Calling case number 2334-6494. This is RSI PP Flipping LLC, MSC City Property Management Group versus all occupants at 19836 Moros Road in the city of Detroit.
Your Honor, Justin Smith for the plaintiff on this case. My P number is 51886. Subsequent hearing for termination of tenancy.
All right. Anyone on Moros Road, 19836? Doesn't appear that anyone is present. Defendants failed to appear. Counsel, are you requesting a default judgment?
I am, Your Honor.
All right, this is a complaint to recover possession of property. No monetary amount is attached to this lawsuit. Default judgment. Defendants must vacate by May 25th, 2023, or writ of eviction could possibly occur.
Thank you.
You are welcome. Thank you, Mr. Smith. You have a great,
One last
yeah.
one, the defendant's talking to an attorney.
Okay. And did we do, we did 687, was that a default?
Yeah, 687.
I'm sorry, 6487.
I have that one as a default. Yes, Judge. Let me make sure that
Not, it's right, it's right.
did we put it on the record?
Yeah, we put it on the record. I don't have the file.
Oh, okay. All right, I'll submit that one too.
All right. We've got two addresses at one. We have a multi-unit. We've got the Brown Brothers, and then we have your last case. All right, I'll go on mute in the meantime. We'll be here. Zoom mute, I mean, if you haven't heard your case yet, let's see. I don't need a Thompson in here. Zoom user at the top.
Yes, this is Thompson.
No, I have your name.
Archie
Is it-
Thompson.
Okay. Yeah, Ms. Thompson, we're just waiting to call your case.
Okay.
Ms. Bonds. Yeah, are we ready? Mr. Christensen and Attorney Bonds, are we ready to call?
I apologize. I believe she's in a breakout room in Kennedy right now.
It looks like she's in here. Oh, she may be logged on to two devices.
Yeah, I am as well.
Okay, you all know what's going on. And
Yes, she's in a breakout room. Yes, Your Honor.
I have more than enough documents to sign in the meantime, so
Okay, thank you, Your Honor. Thanks for everyone's patience.
no problem. Not a problem.
Excuse me, Your Honor. This is Mr. Thompson. Hey, I was trying to let you know I gotta go pick up my daughter from school. She gets out at 3:30. So, I know we waiting for my mother's attorney. So I just don't want it to the point where you call my case and I'm driving.
Yeah. Okay, well,
Cause I leave right now to go to get up there to her school so I can get her on time.
yeah, see if you can leave right now. Just cut your camera up and don't hold your phone.
Yeah, of course.
And drive safe.
Okay.
But hopefully you can get there before we call it, but don't speed trying to get there before we call it, you know.
Okay.
But if you're operating with your camera off, there's not gonna be a penalty. Okay?
Okay.
I know you're here and I appreciate that. And they can't get home from school by themselves. I think it's safe picking her up. So I'm in full favor of you picking up your daughter from school. So do what you have to do. Just get your camera off and be safe.
All right. Thank you, Your Honor.
You're welcome. Okay. Excuse me. Just Sabree squirrel.
You're muted now. When you click on that, you're unmuting yourself. This one, you're gonna yeah. You can hear me? No, I can't hear you. But if you go that either way, you just swipe that way, go the other way. Swipe this way.
Where you at?
We are ready on the last case that I have ending in 489, so long as we have the other side.
Do ours. This side. They both things.
They seem to be in breakout room 3.
Oh, she might have wanted to talk one last time to her client, but we're ready. When she comes back in, we're ready to go.
Okay.
All right, I'll wait.
All right, thanks. Attorney Goodwin.
Your Honor, I believe I'm ready. I did receive that paperwork from the plaintiff.
Is this a resolution? So I might put you behind Attorney Smith.
Your Honor, it's not. It's going to be asking for a short adjournment. I believe I have a good reason for why.
All right, well, let's call it. We're calling case number 2334-6527, Sylvester Brown versus Quentin Brown.
Oh, if I'm gonna say that's something to the judge, go that way.
Good afternoon, Your Honor. Keith Goodwin, PA 3997 on behalf of the defendant.
Quentin Brown.
And I do not know where the plaintiff went off to.
Sylvester Brown. All right, how much time do you need?
Your Honor, 2 or 3 weeks, Your Honor, whichever is available for you.
2 or 3 weeks. 3 weeks, you might have to walk in here physically, so.
Well, let's see, try 2 weeks and then we'll.
May 30th and May 31st. What do you think about those days? Either or.
Yeah, if we can do 30th, May 30th, Your Honor, that works for me.
Okay. Court finds good cause to adjourn this matter. Well, let's see, where's Sylvester Brown? This is his case. Well, I'll set the date. You said May 30th?
Yes, Your Honor, and I'll also inform the plaintiff. I did get his email, so I'll inform the plaintiff immediately about the adjournment date.
Okay, let's do it at 10 a.m.
10 a.m., Your Honor. Okay.
May 30th, 10 a.m. Yeah, okay. Yeah, that works.
All right, thank you, Your Honor.
Thank you. I think I still have.
You still have a few empty.
Here.
Yeah.
Your cases. Cases. Mr. Smith. All right, calling case number 2334-6489. This is Domus PM, Copy Hue Company LLC versus Raya. What is it? Abilene Walker and all occupants on Hartwell. May I have a case?
Your Honor, Justin Smith for the plaintiff. My P number is 51886.
Suzanne Stepich Lawan, P48702, on behalf of the defendant, Taria Appling Walker. And Miss Appling Walker is in the courtroom. Can you unmute and state your name for the record, please?
Yes, Taria Appling Walker.
Good afternoon, Ms. Walker. All right. All right.
Your Honor, I can put the terms on the record if you wish.
Absolutely.
All right. Had another good conversation with Attorney Lawan in the breakout room, and we've resolved this matter, I believe, in the form of a consent judgment that affords under 4B a move date of June 15, 2023. I've crossed off the box that applies to possession judgment for monies that are due. I have checked off the plaintiff has the right to recover possession by the date that I stated. Now, Attorney Lawan, I chose not to check off box number 5, which says defendant may be liable for money damages after moving if rent is owed or if there is damage to the property, based on what we spoke about in settlement in the breakout room, that there may be claims going back and forth. So I thought that we should probably just leave that one alone and not include it in an order for this possession.
Sounds good.
Okay.
Right.
And then lastly, no money judgments due at this time. I crossed off the money judgment block for the numbers. And I did note in paragraph 10, keys to be turned over to management to demonstrate transfer of possession. And I would just merely ask for a signature from Attorney Lawan if that's agreeable, and then submit it to the court.
And I'm sorry, I may have missed it. We did say this is a judgment against all occupants only.
I probably missed putting that on the record, but it is all occupants only.
All right, all occupants are to vacate by June 15, 2023. It's a termination of tenancy matter. No money judgment will be entered at this time. Any back rent or damage to the property, defendant will not be liable based on your based on the record,
Okay, so we didn't talk about that. What does?
Ms. Walker, we did talk about that. We talked about that, but I can explain it to you after the judge talks.
I mean, that's
I'm
all I
sorry.
have.
Okay, well, you're on, right, okay. But if it didn't hear the last couple of parts, is it okay if you just repeat it so I can hear it?
Sure.
Okay,
Yeah.
thank you so much.
I don't have a problem repeating it. It's
Okay, thank you. I'm sorry, the phone was going in and out.
Judgments box on them that say box 5 on the judgment. We were in court, I would just hold this up and you would be signing it in court, but it's harder over the internet. So box 5 says the defendant may be liable for money damages after moving if additional rent is owed or if there is damage to the property. Now, Attorney Smith, you said you did not check this box, correct?
I'm choosing not to check the box, and I thought that it would be good practice not to do so. Because Your Honor, I've discussed that there might be some claims about condition of the property, and I just thought that it would be cleaner that those matters will not be litigated today as of this matter, and perhaps they might never will be, but I can't speak for the defendant in this case. I'm just suggesting that I don't want to check off a box where I have a good faith belief that there could be a dispute on that issue in the future that we're choosing not to litigate today.
Right, okay.
Did that clarify things? So it's just, he's not checking the boxes saying that you may be liable. He's not checking the boxes.
That's fine. It's cool with me.
So that's all it is. And
meaning, okay, so I will only be liable if I made damage.
Correct. If you kick a hole in the wall, then you may be liable. Oh, you kicked in the wall.
Right, okay, I get it.
And
But
likewise,
they
Ms.
still-
Walker,
okay,
you
I
would
get
you would have counterclaims too, I would imagine too. So we're just leaving that for another day if it even happens.
Right, yes.
And
Well, I mean, if they don't come for me, I won't come for them.
That's usually how it works.
I'm sorry. I'm sorry. I'm sorry, Judge. I'm sorry.
No, that's all right. That's all right. And I
I'm
appreciate
sorry.
it. But that
I'm not used to this. I apologize.
No, I mean, it's fine. There's nothing wrong with what you said.
Okay.
Any more questions? Anything we missed?
Attorney Smith does have my consent to sign the judgment.
Thank you.
Okay.
So I don't have to come to court to sign any paper?
Nope.
Okay.
You're good. You're done for the day.
Okay.
And I'll be in touch later today.
And I just have to turn my keys June 15th, right?
Yes.
I just have to turn the keys on June 15th.
Yes.
Okay.
Or earlier, nudge, nudge.
All right.
As long as they're turned in by June 15th,
Right.
you're good.
And Your Honor, I think I'm done as well. I think we disposed of everything very neatly and efficiently.
I think so. I think so.
Oh, that's
Thank you,
okay.
Attorney Devon.
Look,
We'll talk to you
I'm
later,
telling you,
Taria.
okay. Okay.
All right. Okay.
Bye-bye.
Bye-bye.
Thank you so much. Did you?
You're welcome. And you may get something in the mail, but Ms. Luan can guide you through the process. All right. You all right, Ms. Walker? You have anything, any other questions?
Yeah, I'm good. Thank you. I'm
All right,
done.
have a
I'm
great-
done. Thank you. Thank you.
Have a
You
great
too.
day.
Thank you.
Bye-bye. Calling case number 2334-6575, Katrina Mays versus all occupants at 3242 Claremont.
This is Archie Thompson, Your Honor. I'm waiting on my lawyer, Mrs. Bonds.
Katrina Mays is here, Your Honor.
All right, we'll keep waiting.
We just heard from Ms. Bonds. She's finishing up a case in Judge Kennedy's courtroom.
I'm mute now.
Did you see the green box, Tress? Yeah. Yeah, I see it up. Say it up. Say something.
Huh?
Yeah, you can hear them. Hello?
You can hear me now?
Yeah.
I'm on Larry's phone. That's how you can hear me. I'm not on that phone.
You got on your son, you not the green box. Yeah. Trina, you're not muted out. Yeah, that's how
I swiped. I swipe and it says mute. Okay, well, I'm good off the phone then because when I swipe it, it says mute.
No, we can hear you, Ms. Mays. Oops, now you're muted. All right. Are we still waiting on Attorney Bonds, counsel?
I'm here.
Oh, I didn't know you were here. Our party's ready?
Yes.
Audrey Thompson is here.
Give me 1 second, okay? I'm driving. Give me 1 second. I'm about to be able to pull over.
Okay, your case, I'm calling your case second. So
Well, I thought it was all in the same thing. Because
it
it's
is.
both.
Okay. But I can call this case, get this situated. You can still hear me. And then if you need some time, I'll give you some time. But I don't think this is the time where you actually need it, Mr. Thompson. Mr.
Okay.
Christian.
I just wanted to, go first and say what I have to say because basically I've been there at that residence longer than,
All right, Ms. Mays. How's your schedule? I mean, I know you don't just want
Can
to
you hear me
sit.
now? Can you hear me now, Your Honor?
I can hear you. You all have been in court all day. Been in court all day, so
Yes.
yeah, let's just get this, let's get this done if we can.
Please, please.
All right, I'm not gonna kick this can down the road.
Please do.
Okay. So I'm gonna call case number 233467575. This is Katrina Mays versus all occupants at 3242 Claremont.
Self-pleasure has nothing to do with your sexuality.
What the? What is going on there?
What is happening?
I don't know, but that was some erotic stuff that just popped up on the screen.
Yeah, what was going on?
I have never seen nothing like that.
Unfortunately, we have been bombed, and that's why we've been locked in the waiting room.
Wow.
Yeah. I'm sorry I couldn't catch it earlier, so. Yeah.
We got time to do that though. That's
Man, they got out of school already. They out of school.
right.
Yep, sorry about that, folks.
Okay.
All right. 3242 Claremont. Let's start there. Attorney Bonds.
Attorney Keon Bonds, P number 78423, on behalf of Ms. Thompson, who is here who is in court with us today.
All right, thank you. And Ms. Mays, you're here. Can you state your name one more time?
Yes, I am, but Your Honor, I could barely hear you.
Ms. Bonds, Ms. Mays, can you hear me better now?
No, it's very low, and I got my volume all the way up.
All right, let me see if I can. Ms. Thompson, can you hear me?
Yes, sir. I can hear you,
but it's very low.
Okay.
Auntie, on your camera, if you touch your phone, on top where it says Zoom, it might be a microphone that look like it got an X on it. Push that.
Okay.
Okay, that's better. Can you hear me?
Oh, yeah, I can hear you.
Okay, that's better. Thank you.
All right, thank you, Mr. Thompson. All right, let's get this sorted out. So
okay,
this is 3242. Is 3242 the upper or the lower?
The lower flat.
Okay.
The 3242. Okay, lower flat.
So 3242 is the lower. All right.
Yes, sir.
And who occupies the lower flat?
No
Audrey Thompson.
No one.
I am Audrey Thompson. My father gave me the right to move in. He gave me the keys. That's why I've been cleaning up to move my things, and I started moving my things in Your Honor, in January. I've been cleaning up the home at 3242 since October of last year. Because Katrina, because my sister Katrina couldn't pay to have no one to come in there to clean it out.
Your Honor, can I?
That's why the Texas is going to my lawyer stating that shows that where me and my sister had conversation about me getting a dumpster and everything, about me cleaning and putting all the stuff out the house. Those are the text messages that was sent to my lawyer.
Okay.
And she came and locked me up. Huh?
Whose name is on this property? Miss Bond?
Mine. Katrina May.
She just
Katrina
got a quick
May.
deed.
Can I talk, Your
One
Honor?
moment. He asked me a question. May I answer? Can you repeat the question, Your Honor?
Is there a deed in this?
Yes, it is. And I sent it to you, Your Honor. I took it down there.
Okay. You sent it down here.
Yes. It's been my house since 2008.
No, it's not.
Okay.
Our father been living there, and our grandmother was still alive. She was
Ms.
not
Bond.
there.
Attorney Bonds,
Yes, Your Honor.
have you seen the deed? Have you seen any deeds related to this property?
I haven't seen anything, and I wasn't able to get Miss May's contact information before today's judgment, so I could request it.
Your Honor, the first judge, Judge Kennedy, on May 1st, she told me to take the deed down to the second floor of 36th District Court, and that's what I did. I took 2 deeds. I took one deed 2008 when the house was gave to me, and then I took another deed May 18th that I just got. Your Honor, that is my home. My dad left, my nephew stayed there with him, which is the other defendant that did not pay any rent. But we're not here about that, Your Honor. I'm here about trying to get the possession of my home. Me and my sister talked in December. She asked can she come and stay until she got her W-4 end of January. Okay. She didn't move in January. So I called her in February and I was like, sis, you ain't moved in, so you must got all your stuff. Then she said she needed to May. Your Honor, I just want to sell my home and be done with it. I got pipes over there busting. They not paying anything. They want to stay there for nothing, Your Honor. The son want to stay upstairs for nothing, and the mother want to stay downstairs for nothing. It's my home, Your Honor, and I want to sell it. I don't want her in, and I want him out.
There's a deed that's in our grandmother's name. The houses have not even been in our father's name, Your Honor. The original deed is in our grandmother's name. It's not in no one's name, Your Honor.
You never met our grandmother, Audrey. What is her name?
How you telling me? How you telling me, sweetie? You just not coming to our family at 15. I've been with our grandmother ever since I was 14.
God.
When I was
Your
there
Honor,
going.
My father is in his right state of mind. And
Sure
he can tell you everything, Your Honor.
Yes, he is. And he's at a rehabilitation center, not a nursing home. And on top of that, when I was cleaning out the house, Your Honor, they tried to tell me to throw everything out, but I found the original deed that's in my grandmother's name. The deed have not been put in our father's name.
The deed, Your Honor, is in my auntie name. Her name is Diane Ramsey.
No, it's not.
She gave it to my father, Elwood Thompson, and then he gave it to me, Katrina Mays Thompson. Your Honor, you should have all that information.
I have the original deed in my car, and I'm not with my car right now. I have the original deed to the house when our grandmother was owning the house before she died. The stuff that y'all tried to get me to throw away, and I did not throw away. No, and our dad gave me the key to go in there, and she agreed. And that's why, if you look at the text that my lawyer have, is stating that between me and her, she tried to get me to get a dumpster that I could not afford. So I ended up getting a small dumpster, and I put the stuff in the small dumpster. When that filled up, I couldn't afford to get another dumpster. So therefore, I was putting this stuff out in front of the home, which no one was able to. The city did not come and pick up. They had gave my sister a warning ticket, which she did not come out there to pick it up. Yes, and my son had the people from the city they came out there and picked the stuff up, because he should still have the copy of the warning that the stuff that was put out in front that they did not pick up, because someone had rambled through the stuff that I had set out there, that she and my dad had me to go in and put out the house. She's
Your Honor.
telling you that I was not supposed to be in there. How did I get the keys?
Your Honor,
To my dad.
can I talk, please? So, Your Honor, what happened was she tried to move in and she did not come the day she was supposed to. So when January came, January came, January went. I called her in February and said, "Sis, there's no reason to move over there." So then she sent me a
No, you
text.
called me
That's
about the
why
pipe.
I'm doing what I'm doing. And she went and changed all the locks. I
No,
took my
I didn't
deed
change
to the
not
house.
a lock. I still have the original keys.
Your Honor,
If the locks was
can I
changed, how
talk,
did
please,
you
Your
get in
Honor?
there to put the
Excuse
deadbolt
me,
lock
Your
on?
Honor, one at a time, please.
I was just gonna ask you, Madam Court Reporter, how are you doing in getting all this information?
I'm not doing real good, so if they ask for the transcript, it won't be good for them.
Yeah, they're gonna have to watch YouTube. Or
Yeah.
that's what they're gonna need to do, and just play that as an exhibit in court, because clearly we have some issues with communication. But while you all were expressing your viewpoints, I was able to track down not one, but two deeds. First one was filed in 2008. Liber number 47183, page number 613-614. All right, as a reference. This is a quitclaim deed to the property located at 3242. The grantor is Edward Thomas. The grantee is Edward Thompson. Grantor is Edward Thompson. Grantee is Edward Thompson and Katrina Mays. Is Edward Thompson deceased? That's my question.
No, my granddad is not deceased. I'm sorry. They didn't say anything.
Okay.
Oh, I'm sorry. No, I didn't know I was muted. Yeah, he's not deceased.
No, my father is living.
He's in a rehabilitation center called Oakwood Senior Rehabilitation.
All right. Okay. I'm got to mute both of you. Now I have a second deed, Liber number 57652, page 444. This is coming from Edward Thompson to Katrina Mays, solely to Katrina Mays, signed by Edward Thompson, drafted by Aaron.
Excuse me, Your Honor, but that's not our father's handwriting on that deed. She signed it. My father did not sign it. That's not his handwriting. My father didn't sign that deed over to him. If you look at his state ID and his driving license, those handwriting would be two different handwriting. That would be her handwriting and not his.
All right, Attorney Bonds, what do you think? I really want to remove this, but if
because I've been trying to get down there to probate court about it. Me and my other sibling.
you all have a title issue, Ms. Mays. You're gonna have to clean up your title because there are two circulating deeds. This is a family dispute, and I don't feel comfortable removing one person or this is not going to solve this issue.
That's why I wanted to go to probate court.
I can rule on it, and it's my duty to make a judgment call, but your son is upstairs, Ms. Thompson, and you moved downstairs. So if you remove one and not the other, I don't know how.
Because Your Honor, I've been locked out. I haven't been able to get in since March the 1st because Miss Mays put a deadbolt lock on the front door. And then she also had the back door boarded up with 2x4s to where I can't get back in or out and my things are in there. I've been staying with friends and family since March the 1st.
So 3242 is deadbolted.
Yes, sir. It's been that deadbolt since March the 1st. When she did it, I called her. I lashed out on her. I even texted her and told her that I was coming over there with the police because she was wrong to come and put a deadbolt lock on there. So how can I change the locks? If I'd have changed the lock, she wouldn't have been able to get in there and change and put a deadbolt lock on the door, Your Honor. That's what she did March the 1st, and I sent those texts to my lawyer.
All right, so who owns?
She put a PPO. She put a PPO out on me on that day.
Oh, that's who owns 3244 Claremont?
But my granddad, well, now my auntie. It's both. It's up and down. So he owned both of them, and then now my auntie do.
Okay, and this is according to the deed. The second deed that was filed in 2022 that transfers both addresses to Ms. Katrina Mays. And you're alleging that this is not her signature?
No, that's not my dad's signature. No, she signed it. It's not our father's signature. Because I have a state ID and we have driver's license to show that that's not his handwriting. The last time my dad signed some papers was when I was with him at the rehabilitation center when he voted for the last governor. That's when he put his hand, John Hancock, on something. Other than that, my father, she was signing stuff in his name. Her and her daughter would do that.
I'm going to, you all need to file a quiet title.
Mm-hmm.
You all need to file a quiet title to really get to the bottom of this.
Yeah, I just got put in the middle of it between her and my mom.
Other sibling, not to cut you off, sir, but my other sibling, my brother, which is Gabriel Hill, he's another sibling of my father's. My father had 3 children, me, Katrina, and Gabriel.
Is there a probate estate open?
I've been trying to do that before we came to 36th District Court, Your Honor. I just finally got the number from there. I've been trying to do that, but they had me on a recording, sending text messages to them, and they text me that information for the probate court. That was April, the end of April, right before we went to court the first time, which was May the 1st on this court case. Yes, I've been trying to get to probate court, me and my brother, on this matter. Because she took over everything on herself instead of all 3 of us together with it.
All right, I'm going to mute you for a second. Let Ms. May speak, and then Ms. Bonds, do you have anything to say?
I would like to hear what Ms. Mays has, and if she could put her email into the chat, I'd be very much appreciative at the moment.
This is all new to me. I don't know how to put an email in the chat, Your Honor. This is my first time doing a Zoom court. All I know is I have power of attorney over my dad. I have the paperwork. My dad had a heart attack last year in January. I'm power of attorney. When I put him in a nursing home because he couldn't move back in the home because it wasn't safe for him to be there. And that you got the nephew staying there that haven't paid rent, not paying rent. And then you got his mother trying to move in there. It's my home. I want to sell my home. They just want to stay there for free for nothing. And I'm tired of it. You can't stay nowhere for free. He's been there over 4 years. The last year my dad been in a nursing home. He haven't even went up there and seen him. My dad is in his right state of mind, and we have to get to the bottom of it. I can go to the nursing home, and I can let you talk to him, and he can tell you. He is in full state of his right state of mind.
I would love to talk to Mr. Thompson.
How can I? Can I
Because look,
call him on the phone? Can I call him on the phone, Your Honor?
I want to really know is Mr. Thompson.
Huh?
I want to make sure it's Mr. Thompson. So
Well, she's on the phone. She'll be able to see him. I mean, my dad don't know how to do FaceTime. But if I call and say, Dad, she know his voice. Larry, let me see your phone.
And he also goes back and forth in dimension. He's
No,
been
he don't.
inside
No,
of
he don't,
dimension.
Your Honor. No, he don't,
If
Your
that's
Honor.
the case, how can he tell you I
All
brought
right,
you there?
evidentiary hearing, okay?
Huh?
We're gonna set up a hearing just for evidence.
Okay.
In this. So I want you all to prepare your evidence, and this goes for you too, Mr. Thompson, if you have anything.
Yeah, I was trying to speak, but they was going back and forth. I was not getting into that.
Oh, I'm sorry.
That was great decision, Mr. Thompson, in my opinion. Okay. So, I mean, you might have a lockout situation going on. There may be other issues, but let's put it all here at one time and present it. I'll keep these cases together. Mr. Thompson's at the bottom unit. Ms.
I'm at the
Thompson
top
is
unit.
at the top unit. Ms. Thompson's locked out at the bottom unit. Ms. Mays, you're saying she doesn't belong in the bottom unit. Technically, you have a deed that says your name and you're entitled to that property. So I'm going to leave everything status quo as it is. I'm not going to order for you to remove the bolts, even though you may potentially be liable for an illegal lockout if that is the case, but I'll leave it to the parties. All right. How much time, Mr. Christensen and Ms. Bonds, do you think is needed? How much time do you think we need? I want to get Mr. Thompson. Obviously, we can't bring him in. You all might have to go to the actual rehabilitation center / nursing home, whatever. Whatever it may be. And I have both deeds, but any other information, I don't want to make a determination just yet because I could dismiss the case and leave it to circuit court, but I don't think that would be solving too much of the issue right now. So
what we do now, Your Honor?
Respectfully, Your Honor, Mr. Thompson himself isn't contesting the will, I don't believe. I feel like Mr. Thompson is primarily concerned with the fact that he does have a tendency of some kind and he's not able to get to his basement or to the basement to get his things. According to my client, Mr. Thompson, you can testify to this too. If you like, it's his washer and dryer down in the basement. And so he feels a little caught in the middle of all this, but he would like to at least get his things and be able to have access to the basement.
Okay, well, my whole thing about the whole situation, like I said, I don't want to get in between my mother and my auntie. All I wanted to say was that I've been there. I've been written from my granddad. And as far as I know, that it was my granddad's home, not my auntie's. When my granddad had his heart attack and was not coming back home, me and her had a conversation about she was selling the house. It was okay with that. I wasn't mad or nothing like that about it. I just told her, she just told me once she sell it, she was gonna give me some money from it to be able to move. But after everything happened between her and my mom, I come home from work, I got a notice stating that I gotta move out. And I got caught in the middle of all that. And I feel like that's not right for me getting caught in the middle of all that, especially by me having my daughter. So now I got to try to figure out what I'm going to do with me and my daughter and where we're going to stay.
all right. So Ms. Mays.
Yes.
Can you
I'm sorry, I cut you off, Judge.
Are you restricted from, you're restricted from the basement, Mr. Thompson?
Yes, that's where I washes me and my daughter's clothes. How I go into the basement is through my granddad's home, and it was always like that since I've been there, and now I can't. So
Your
I have to
Honor,
go and wash. I have to go pay money to wash our clothes.
Your Honor, the reason why now it's a two-family flat. When he
I know
moved
you can
there,
access the basement, you can
it,
access floors from the basement.
Your
Okay?
Honor, it's a two-family flat. He's got a refrigerator up there that he should have took out long time ago, and that's blocking him from getting down in the entrance. So
It's
that's what he
more than
started
just
going on
a,
the other side.
I'm sorry,
Had he
it's
threw
more
that
than just a
refrigerator away,
refrigerator. It's just more than a refrigerator. It's a whole lot of stuff that was there before I moved there.
okay.
And
All right, everybody. You all keep doing this, and it's 4:15. So, this is what we're gonna do. Ms. Mays, I need you to unrestrict the basement. That Mr. Thompson has full use and enjoyment of the property. I'll leave the lower unit to be dealt with at another time, unless Ms. Bonds, you have a motion. But right now, I want to know, you all need to do an evidentiary, we need to do an evidentiary hearing to determine if there's really an issue. I want to speak to Mr. Thompson. I want Mr. Thompson some access to determine whether, I can't determine the validity of a deed. That's not my role as a 36th District Court judge. I can look at it, I can't determine and make a determination of title. But based on the face, Katrina Mays has a quitclaim deed. And you all are saying that this is not Mr. Thompson's signature. So if you all have a quiet title action, this is going to be on hold until the end of the action anyway. If I make the wrong decision, Ms. Thompson might be out of here, or Mr. Thompson, Curtis Thompson, may be homeless or without a property, and Ms. Mays didn't properly own the home. So I'm just gonna adjourn this matter. We're gonna have an evidentiary hearing, but in the meantime, Ms. Mays, please allow Mr. Thompson access to the basement. I'm not, and you may be liable for a lockout depending on the facts dealing with the lower unit. But as it goes for case numbers ending in 576 and 575, which is the same parcel, but different addresses. When do you all want to come back? Mr. Christensen, when would you like to come back?
Your Honor, to be honest, I'm a little confused as to what Mr. Thompson's evidence would be that he's producing. Mr. Thompson's, I don't believe he has an action in probate court, but I would like to, I mean, I don't know. I would assume that this will take a little bit of time to unravel the deed and to get from Ms. Bonds to get her evidence prepared. So maybe it's a question better for Ms. Bonds.
I think so too.
Before I ask that question, Ms. Mays, were you able to see my last text, my last message about your number? And can you verify if that's the correct number for you? In the chat? Ms. Mays, you're currently muted, so we can't hear anything that you're telling us.
Okay, can you hear me now?
Yes, ma'am.
Okay, I'm sorry, but this is new. This is my first Zoom court. I don't know how to get to the chat.
Tell me your number or your email, and then
Where do I
it'll be done.
put it at?
Just tell her.
Where do I put this information at?
You can tell her verbally.
Okay, can I tell you? Can I tell
Yes,
you my
ma'am.
email?
Yes,
My
ma'am.
email is Trina, TRNA, love, family @gmail.com.
So TRIAN,
Yes.
All right, thank you.
You're welcome. And what else do you need?
I believe your number is correct, but I will email you to confirm. So all your information is on the internet. All right.
Right. And this is what I'm going to do. Matter ending at 23346576. I'm going to you have any motions on that, Mr. Christensen?
Basically, just motion for injunctive relief as stated with as to access to the building. I feel like this case is contingent on the other case against all occupants, and then that case is probably contingent on another case in terms of who has rightful possession, who has title. So at this time, I just ask just for the motion for injunctive relief and allow Mr. Thompson, Curtis Thompson, access to the basement.
Okay.
Your Honor, when I give him access to the basement, I don't want to give Audrey Thompson access to the house. She haven't been there. She don't have a lease. She don't have the right to be in.
I can't
So
get
when
in
he
and out
has
of
the
there, Your
access,
Honor. My things are in there.
You are to grant Curtis Thompson access to the premises. I'm not ordering to grant Ms. Thompson. I'm not telling you to or not to. And Mr. Thompson, are you still?
Yes.
What are you supposed to be paying your grandfather?
Okay, now this is what's going on. Since my grandfather been gone, I have not been able to pay anything because she stated that she didn't want any money from me.
All right, so say that, okay, let's get this, Ms. Mays, are you willing to accept anything from Mr. Thompson?
I just want my possession. I want my home.
All right, never mind. All right, never mind. Okay, so I'm gonna adjourn. I mean, this is a very simple question. How much can you pay? How much do you want? Neither one of you all answered. I'm not gonna order anything. I think it'd be reasonable to pay something to maintain.
Yeah, that's what I said, the same thing.
Well, okay. I was just.
Go ahead.
I'm sorry, I was just pointing out that it was a termination case.
Yeah, I explained to my auntie, I said, if I could pay you or whatnot to be there at least for a couple more months or whatever till I get everything straight, then I could be able to do that. But she said she didn't want no money from me.
All right, well, try to work that out with Ms. Mays. I'm not going to order any money. If you all obviously can't live in a property, there's some expenses that are there, but this is a termination of tenancy case. So I'm just going to leave it to you all to work that out. So I'm going to adjourn this matter with Mr. Thompson. Let's adjourn it to. How much time do you need to file your quiet title, Ms. Bond? It'll take a while.
Yes. Good Lord. And we have the other clear title issue that's for the 31st. 1 moment, please.
Let's come back. Let's come back in a month.
Okay. Also, I wanted to ask the court if they will allow Ms. Audrey access to the home, at least into the evidentiary hearing, if you are considering a lockout judgment.
Or do you have anything that you need to get retrieved from the home, Ms. Thompson?
Yes, I still have clothes that I need to be getting in and out of there, yes. And I still have, like I got my china cabinet and a lot of my household products and stuff for me cleaning in and out of there, yes.
Okay.
Yes, I still have things in there.
Your Honor, she never was living there, Your Honor. She put stuff in there, but she
Yes,
started
because
getting
I
mail
was
there.
sent to live in there.
This is what I'm gonna do. I'm gonna order that you allow Ms. Thompson access to the property. I'm not gonna dismiss your cases because these are your cases and you have presented a deed. And when
So
can
I
we?
feel like, Your Honor, if I have a deed, okay, I gotta let Mr. Thompson go to the basement. Now you saying she can move in. It's my home.
It's up. I feel like
I had already
there's an issue with the deed. And until we figure that out, either I hold this in advance and you don't get a result until there's a circuit court resolution. We have an evidentiary hearing and I say, oh, this isn't an issue and grant you your judgments, or I rule and I'm wrong, which is possible, but I'd rather be a little bit more thorough in finding out who owns the house. But I can't make a determination. I can't grant you title, but I can see what's going on. So let's have an evidentiary hearing. What's a good day? Tell me. We'll do it on both. We'll just require evidentiary hearing on 575. So we're gonna adjourn 576 to July 15th or July. Let me just get a date. I don't want to put it too far out.
Right, because my pipes over there is already busting, Your Honor. The house is in bad shape, and I just don't want the winter to come back. And then I'm dealing over there with the pipes busting and everything, Your Honor.
Yeah,
I just want my home so that I can sell it.
There's no pipes busted. It's only one pipe that got a crack in it that's in the bathtub, Your Honor. She don't even know because she haven't even been in the house, Your Honor.
All right. I'm adjourning both matters to June 20th at 10 a.m.
Okay, so you say you're gonna go and talk to my father, correct? Or somebody is?
No, I need your father available. You may have to go to the nursing home.
I will. So that day he will be on court with me?
Yes.
Okay.
And we will be in person, but I'll allow for Zoom for this hearing due to circumstances.
Okay.
And any documentation, I have those 2 deeds for anything that's being contested. Please be prepared to provide that on that date. And
Well, Your Honor, I don't know what else to provide. Like I said, the first deed.
And that's it. You have a deed. You actually have 2. I just want to hear Mr. Thompson say he signed his name on this deed.
Okay.
The real deed. Yeah, the real deed.
So June 30th?
If you have a real deed, the 20th, or email it to parties before the 20th, so everybody has it. And I think this will be resolved by June 20th.
So you want me to email it to their attorney?
Your Honor, can we do the 19th or the 21st? The 20th is a lecture legal day.
Let's do it first.
Thank you.
No, just it's all free for you.
And can I have your email address, please, so I can email it to you?
Just let me make sure of that. Yep, it's all free.
Okay, what's that?
July.
Okay. I just put it on there, but we're gonna have them anyway.
Yep.
Anyway. So yeah. What date was that? You said, well, we can go, you said 21st works better?
Yes, please.
All right, June 21st then.
Okay, the attorney, can I have your email address so that I can email you the documents that you need?
Check your email. I just sent you my information.
Okay, so I just need to email you my deed? And do I need to email the other attorney the deed too? Both
No,
attorneys I need.
It's two separate cases, so, oh yeah, well, maybe you do, because you're on both of them, so.
So I need to email both. Can I have your email address, the other attorney, please?
Yes, Ms. Bonds and I will send you our email addresses.
Okay, you have mine. You heard me tell her the trinalovefamily@gmail.com.
That's right.
Okay.
All right, thank you, parties. I know this has been all day, but we still have to get to the bottom of this, and it seems like a family issue that kind of bled over into landlord-tenant court. So let's clear up the title. And maybe there is no issue with the title, maybe it is. I'm not gonna make that determination, but if there's information that we can put together to paint the full picture, then I'm willing to entertain that before kicking it out to circuit court. So that's where I'm at.
The last question I have is, you said to let Mr. Thompson back in the basement, and you saying that she can move in the house to June 30th?
I'm already moved in there. My stuff is already in. I'm already moved in.
Your Honor, she's not there.
My
She's
clothes and my
cleaning
stuff and
over
my
there to clean up,
Chinese
Your Honor.
is in there.
She's not there, Your Honor.
Those are my things that's in that house.
Ms. Mays.
Yes.
Wow, you should Google illegal lockout.
Your Honor, I didn't illegal lock her out. That's
Yes,
my
you did.
home. And she went over there.
I
Your
just
Honor.
said, I'm done with the hearing. We're done with court today. I'm gonna let my court reporter and my clerk go home. But I want you to Google illegal lockout. Just look at what it says and look at the penalties for illegal lockout. Okay? Understand what's going on? I'm not telling you that you did, but that's something that may be relevant in this case. So please remove the locks that were changed so that Ms. Thompson, I'm not saying she has a tendency or not, but if she was in the property and her stuff is in the property and now she can't get in the property, that seems to be an eviction because she can't access it. And what's the point of coming here if we can just change locks? So if I allow that, then I would set a terrible precedent, and maybe not in this case, but in a lot of cases, it will lead to some draconian results. So yes, please remove your locks. I'm asking you to allow access until the next hearing. I haven't dismissed your case, so you still have grounds, and in the event they can't prove anything on the deed being fraudulent, then you get your eviction. I'm not on one side or the other, but I want to make sure I'm not putting anybody out unlawfully or without legitimate understanding of the facts. So it's an inconvenience. It's a month. I'll see you all back in a month, and be kind to each other in the meantime.
Okay, have a good day, everyone.
Okay, Ms. Bonds, is it possible way that I could talk to you or call you today?
I have to call you after I'm out of candy. I'm still
Okay.
in court. All right.
Okay, thank you, Ms. Bonds.
You're welcome.
Thanks to the judge. Thanks, everyone. Thanks, court staff.
Have a good day.